May I please your lordship? My lord, in item number 6, I have filed one additional affidavit. Deputy license.
Court number 404 is a very good.
Nothing problem. It will be there in the list. Nothing. Last of it was taken. We cannot impose it. All you can say is the requirement to take up the matter. That's when to be taken up. Item 4.
May I please, your lordship? Lordship, in item number 27, I want to file additional affidavit, my lord. 2 weeks time will be granted, my lord. Lordship.
May I please, Lordship? With permission of the other side, your lordship, I beg to mention item number 34, 35, and 36.
34, 35, 36.
Yes. Senior Deenat is suffering from severe back pain, lordship. And Colita.
May it be please, your lordship, I beg to.
Yes, lordship. Yes, lordship.
Yes, my lord, I'm for the petition.
I beg to mention item number 18, lordship. Yes.
18 we will not like to adjourn because we have specifically listed for being taken up. What is the reason?
Lordship, my senior, my brother-in-law is.
When did he die?
Today morning, lordship.
This morning. Okay, today we adjourn. Next day, no adjournment. It's stated that MSK Devi and counsel for a petitioner is in bereavement adjourned to be listed on censor. Bereavement doesn't mean it'll be adjourned for 2 weeks. We'll take it up very soon.
May I please, your lordship? Lordship, in connection with item number 1, your lordship, I am not the conducting counsel.
When the item will be called, you please say whatever you have to say.
Item 4 for motion.
Yes,
May I
ma'am.
please your lordship?
This
Lordship,
is
father is
important.
Jadu Sheikh. It's at page number 14, lordship.
Jadu Sheikh.
Yes, lordship.
Who is Jadu Sheikh?
Father of the petitioner.
Father. Molobi. Gaon. Borua Pathar. Komoria. Yes, now which document will show you please?
77 voters list, lordship.
Page number
Page lordship 18.
18.
Although mother's name is Fuljan, here it is written as Guljan.
Page number 18. Let us take a look. Jadu Sheikh. Where is Jadu Sheikh?
Jadu is Bewa. Meanwhile,
So where is the voters list of Guljan and Jadu together? Because Guljan is aged about 68 and Jadu in 66 was 45. So Guljan must have been 58.
Lordship, in 70 voters list, she is known as Fuljan Nessa Bibi. Page
There are-
15, Lordship.
15.
That discrepancy I have stated. Mother is Guljan.
Jadu Sheikh and Fuljan Nessa.
Yes. Nessa Bibi, but her name is Fuljan, but in 77 it's Guljan.
Abdul Jamal is the son of Jadu.
Yes,
Hmm.
yes.
Is the voters list all right? See, Jadu is 49 years. Fuljan is 39 years.
Yes, and he
And
is-
Abdul is 31 years. So what, she became a mother at the age of 8 years or what?
not
Fuljan.
possible, Lordship.
Hmm.
Let me take the.
Something is wrong.
Yes, Lordship, let me take instruction.
And secondly, you see, this Guljan Bewa
Yes, Lordship.
is now again 68 years.
Yes, Lordship.
And what happened to Abdul Jamal?
Yes, certified copy is not being provided, not even the normal.
Suppose this Guljan and Fuljan.
Yes. Then also.
Suppose
SB
we accept that it's a
Understood.
incorrect spelling. But what happened to Abdul Jamal?
Yes, Lordship. Maybe a week's time may be given to us so that.
The
we can-
petitioners may produce the complete voters list of 1966, 1970, and 1977 of village Borua Pathar for examination of the court.
Yes,
How much time you want? 2 weeks,
yes, Lordship.
just after 2 weeks.
Deeply obliged.
Item 5.
May I please? School record is called.
Sorry.
School admission record is called.
School record. If we
Lordship,
have it.
records are
let
there.
us see. Where is the transfer certificate?
Page 84 here. Page 84.
84. Saina Begum, daughter of Jalaluddin. Where is the name of Saina Begum? Serial number?
Lordship, serial number is not there,
Serial number is also almost not there.
not there.
So, but where is the name at least?
The middle part,
Middle, Kalpana Bala, Manjuri, Sujit, Abdullah, Saina Begum. Saina Begum. Daughter of Jalaluddin. Where is the information that he is from village Dumergudi? No, certificate is given, he is a resident of village Dumergudi. Where is the information in the admission register? He is a resident of Dumergudi.
it is written there.
Sorry,
Dumerguri is written there in the admission register.
Debohai aru Chikona. Debohai aru Chikona. To sign on.
Lordship. But in the.
You have read this one? Take a look, it doesn't look, it looks okay, in fact.
But I think it's Begum there and here it's Shaina Khatun. Then there's a change of name.
Sorry, you have to come a little to your left.
There's a change of name. My friend's telling me that it's written Shaina Begum there, but the petitioner is Shaina Khatun, Lordship.
No, Saina Begum.
Begum, but the petition is Petition is by the name of Shaina Khatun.
Khatun.
Yes, Lordship.
And to whom the notice was issued? Notice was issued to Khatun or Begum?
Khatun.
Khatun, yes.
Khatun.
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 Then is it the same person, Khatun and Begum?
Lordship,
Why two names?
father's name is same, your lordship.
That doesn't mean this person will have two names.
Lordship. But in the result record book, the name of the Saina Begum is not here. The class one result record book.
Okay, in admission, class register is not there.
Class register is not there, but a result record book is there. In this result record book, name of the petitioner is not there.
Maybe she never passed out, took admission.
Let's see if
No.
Clearly examination.
Understand, possibly had taken the admission, but after a few days discontinued.
Maybe.
But for our purpose, relevance is the information as to who she is, who is the father, and where is the residence. But whether the student completed or not is not relevant for us. But how do you explain Begum and Khatun?
Lordship. Before marriage, I think it was Begum. After marriage, it written as Saina Khatun. There is
Your
some
thinking
discrepancy,
is not the basis of our judgment.
Lordship. I have to take in instruction.
The petitioner relies upon the transfer certificate of MR Memorial High School, Dumerguri, wherein the information available is that Saina Begum is the daughter of Jalaluddin of Village, Dumerguri, Part 2. To verify the authenticity of the certificate, we required the admission register in original of MR Memorial High School, Dumerguri to be produced before the court. The admission register so produced shows that Saina Begum
Lordship, I have just a small tray, Lordship.
just a minute. No, we are not completing it today. Wherein around 2/8/1980, কি করবো? Saina Begum took admission around 2/8/1993, and her name of her father is shown to be Muhammad Jalaluddin, being resident of দক্ষিণ বারাসাত কিবা তেনেকুৱা হ'ব। ডুমেরগুড়িতে আমাকে লিখতে হবে। ডুমেরগুড়ি লিখে কেনেকে short form লেখা এবং variant is now Geo. I think it is Dumerguri. It is Dumerguri, but headmaster believes in writing it in short form, like not Guwahati University, Geo. In that manner it is written, but it is Dumerguri. Verified, and admission register also contains the same information. What do you want to
Lordship,
say?
This certificate which is annexed to the additional affidavit, this is of some Saina Khatun, Saina Begum. Lordship,
This is also Saina Begum.
yes, but the petitioner is Shaina Khatun. There's a discrepancy in the name also. And even this school living certificate has been obtained only in the month of April this year.
That
After,
no, that doesn't make any difference.
Lordship,
Even
the
if it is
difference
obtained
is
today
that
also.
The person before this court and this certificate are not the same persons. This is what I want to
Maybe.
submit.
Lordship, this,
This-
Make a verification, submit a report.
this
Now
certificate, has-
that now the headmaster will have to say whether these are the same people because the school.
No, no,
teachers
headmaster
taking-
won't be knowing because the present headmaster was not there in 1983
And how did he issue this on the?
on the basis of this one.
But on the basis of this, then here it is Khatun and here it is Begum.
That you inquire whether this Saina Begum of the admission register and Saina Khatun are same person. You make a verification, submit a report.
And when and how did she become Khatun lordship? That my friend.
No,
has to-
that's why we submit a report before us. Inquire.
He will, they will have, to. He will.
He'll also explain, you also make your verification.
That is absolutely not clear lordship because. he is
Understand?
bringing
So
in
therefore you make a
something-
verification.
He has to prove that he is the same person. She, I mean, I'm sorry, lordship.
Understand? Why are you not undertaking to make a verification? Use your police force and make a verification. He'll also explain. But it is noticed that the writ petitioner proceeding is Saina Khatun and not Saina Begum. The petitioner to explain as to whether Saina Khatun and Saina Begum are one and the same person. Respondents in the Home Department may also make their own verification and submit a report before the court as to whether Saina Begum of the admission register of MR Memorial High School, Dumerguri, is another person and not the writ petitioner.
One thing I would just like to ask lordship, my friend has,
The admission register is written back.
he has filed the
First of it.
petition in the name of China. But all his documents are in the name of China. Why this
China.
Spelling.
Spelling also different.
spelling is also different and here he writes CHI and there SAY.
These are, we cannot pass a judgment on that they are different person. You make a verification, tell us.
this is phonetical problem here.
Yes, next item 6.
Item 6. First of all.
May I
Please
please
file
do
affidavit required by the order 26.
Lordship, may I please, let this take up as a last item, Lordship, because additional affidavit
Coming.
already I filed.
Timely.
Deeply applied.
Item 7.
Your lordship, actually engaged advocate won the way is part of the matter for the timing.
Sorry,
Engaged counsel already won the way is part for the matter for the timing.
Item 8.
for the date.
The time being.
Time being.
Yes,
May I
Mr.
please?
Rahman. Rohila Begum,
Petitioner's father name appeared in voter list of
page
9,
number
page number 38, your lordship.
38. Apas or Kotha.
Shirazul Haq is the father. And grandfather's name is appeared in the voter list of 1966, your lordship, page 33, 32.
Who is it? Tomezuddin.
Thomas
Tomezuddin is the grandfather.
grandfather,
And who is the father? Sirazul is the father.
Shirazul,
And who is the petitioner? Rohila. Which
Rohila.
document will show Rohila?
Kabin Nama, your lordship, page 53,
Space
53.
53.
There is a shifting, your lordship, father was shifted.
Prove it.
Page 44, your lordship, cell deed is there. Registered-
Sorry,
Page 44,
Ah.
registered cell deed is there.
44. Sell it of what?
He purchased the land.
Okay,
in the
Sirajuddin of Hapachar had purchased land. Where did he purchase?
Amguri part one.
Amguri. So,
Now he is in Amguri part one. Kabin Nama, your lordship.
okay.
Notice, Lord.
P. Rahman. বাকি এনে দিব। Petitioner relies upon the voters list of 1966 of village Hapachar, which contains the name of Tomizuddin, son of Sikot. That's serial 347. It is claimed that Tomizuddin is the grandfather of the petitioner. Further reliance is placed on the voters list of 1989 of village Hapachar, which contains a Sirajul Haq, son of Tomais. It is claimed that Sirajul Haq is the father of the petitioner. By the sale deed dated 16/10/1985, Sirajuddin, son of Tomizuddin of village Hapachar, purchased a plot of land at village Amguri Part 1. It is claimed that thereafter Sirajuddin is living at village Amguri Part 1. The petitioner relies upon the Kabinnama, which contains the information that Rohila Begum is the daughter of Sirajul Haq of village Amguri Part 1. Accordingly, a claim is made.
Hello.
Item 9.
May I please, your lordship? My lord, the petitioner's father's name appears in the voters list of 1966.
Item number 9. Okay. Voters list of
1966. my
Page
lord.
number?
Page number 23, my lord.
Dharmapur Nonke.
Yes, my lord.
Who is the father?
My lord, Hazrat Ali, my lord. Serial number 94.
And petitioner is Asia. Which document? Asia.
Uh,
Which document to show Asia is the daughter?
My lord, I am relying on the evidence of DW2, my lord.
Who is he?
My lord, he is the son of Fatiq Ali, whose name appears at serial number 95, my lord. Fatiq, serial number 95.
Who is he?
DW2 is the son of Fatiq.
No. Hazrat Ali is the son of Karim. Fatiq Ali is also a son of Karim.
Yes, they are brothers.
And their brothers. So son of Fatiq had rendered evidence.
Yes.
You should notice. The petitioner relies upon the voters list of. Where is the first one you relied upon?
1966, my lord.
30?
1966, Page.
Which page?
24.
Acha, this itself is. Now, what is this of 1966 of village Dharmapur Nonke, which contains the name of Hazrat Ali, son of Karim, at serial 94, and Fatiq Ali, son of Karim, at serial 95. It is stated that Hazrat Ali is the father of the petitioner, whereas Fatiq Ali is the brother of the father. Son of Fatiq Ali, namely
Samsul Haq.
Samsul Haq, had rendered evidence before the tribunal that Asia Khatun is the daughter of Hazrat Ali as DW2 of the same village. Where is DW2 evidence?
Evidence, my lord.
Where is the evidence of DW2?
My lord.
That's why. No, first let us look at the evidence. Which page?
My lord, after 1970, my lord, the petitioner's entire family shifted to village Shubhuwarjar, and thereafter all their names.
No, yeah, those are very well. But where is the evidence of? So you prove that.
That Samsul Haq is the son of Fatiq Ali.
And Fatiq of Dharmapur, not any other Fatiq.
My lord, there is a voters list of 2000.
It is stated that the family of Hazrat Ali and Fatiq Ali later on shifted to village.
Shubhuwarjar.
Okay, now to leave which the petitioner may produce any relevant material which may substantiate the shifting. Notice na lage, First, you show the shifting. We'll issue notice. Pass the entry.
The space where its name appears with the father, Fatiq Ali, Samsul Haq's family.
There is a voters list of 2005. I'm sure.
Item 10.
Modwara Khatun.
May I plead your lordship? Actually, English council on the way, please pass over the matter for the time being.
Item 11,
Madam Ghosh, where is she?
May I please?
Abul Kasem.
Yes, Lordship.
Now, who is the father?
Father is Kalame. It's an ex
Yes,
parte order.
party order, it appears.
Yes, Lordship.
Pay 5,000? Pay 5,000, go back.
This.
Sorry.
Yes, he is a cancer patient, Lordship. He's,
Cancer patient.
yes, Lordship. His cancer document, page 60. So
Yes,
he will
wherever-
pay, Lordship, but
Less.
little bit less. Let him also get the pinch. So, but little less. Lordship.
Yes,
Cancer was detected very
Sorry?
recent- Cancer was detected very recently.
no, the money he'll have to pay now.
I know that lordship.
That money he may require for,
This order is of 2008,
understand,
ex parte order of 2008.
understand,
lordship.
but the money he requires for his treatment as of now.
I know that lordship.
Otherwise, complete cost, but because of transfer, some concession. D goes, it will here to liquidable. FT Furnace Tribunal 2 Borpeta, case number 28306, FT second Borpeta. Where is the expertise order?
Ex parte order is at page 21.
Right.
21 is the typed copy, Lordship, and
Okay.
the certified copy, it's an handwritten order.
Hmm.
Certified copy, it's starts from 25.
Notice served.
He did appear lordship, but then later on he
The
did not complete the proceedings.
notice was served upon the petitioner. He initially appeared, but thereafter did not appear without any acceptable reason. It was no notice any infirmity, but however interest.
And then
Lastly, it is stated that presently the petitioner is a cancer patient, and therefore a prayer is made that a cost to be imposed for the earlier non-appearance be reduced to some extent. Accordingly, instead of a cost of 5,000, the petitioner to pay a cost of 2,000 to be deposited before the advocates. What is that? Advocates benevolent,
Benevolent fund, that's here in the High Court.
just check up.
let him play in DLSA, Lordship, if Lordship pleases, DLSA at Borpeta.
So your bar president had made a request
Okay.
that
We need some funds here also in the
Okay.
benevolent fund.
DLSA have enough fund for them. It comes from the many sources. To be deposited before, to be deposited in the advocate benefit fund of the Guwahati High Court Bar Association,
Deeply,
and to appear on so and so after showing proof of the payment of the cost.
deeply.
12 to 14 for admission.
Just coincidence, right?
Guwahati High Court to the benevolent fund. They will actually form to the bar association. Whether they give you a person. Naturally, that I would be.
Item 12 to 14. What a day. Aziko Gina, nine. And who is appearing? We'll take up after some. Let Mr. Mojumdar and Mr. RKB Chaudhary, I think they were addressing the.
Yes.
Item 15.
Your lordship. Lordship, my father's name has been recorded in voter list of 1970. Lordship. My father's name has
To
been
cons-
recorded in the voter
just
list of
a minute.
1970.
How Abdul Haq of 2005
Lordship,
of village Modatori and Kalamia of 1970 of Sangmaji Mikir Pothar are one and the same person. I think we required the SP also to make an inquiry.
Yes, Lordship.
Is the report available?
No, Lordship.
Lordship,
By the, sorry,
Kalamia is his nickname, Lordship.
what is the difference between a statement and evidence?
Lordship,
In law, what is the difference between a statement being made and evidence? What is the difference? Or it is one and the same? No. Produce material to show.
In this time may be allowed.
By the order of 7/6/2023, the Superintendent of Police Border Hojai was required to submit a report whether Abdul Haq of the voters list of 2005 of village Modatoli and Kalamia of the voters list of 1970 of village Sangmaji Mikir Pothar are one and the same person. It stated that a report is not available. We have noticed that the Superintendent of Police Border Hojai is not cooperating in the matter in the required manner. The earlier order of 26/5/2023 was for a report, but instead of giving a report by the Superintendent of Police,
Yes, sir.
a note, there is comma, a report of the Sub-Inspector of Police was sent before the court, and exception was taken to the said act of the Superintendent of Police when the matter was taken off 7/6/2023. Accordingly, a direction was issued that the report should be by the Superintendent of Police and not a report of any other authority to be forwarded to the court. Today, when the matter is taken up, the report is not available. List on so and so for the report or the personal presence of the Superintendent of Police Border Hojai.
2 weeks time.
Next week. Enough time is given. He is not doing his work, this man. Copy of the order to Mr. G. Sharma.
28th June.
Abdul, yes.
Item 16.
May I please order? Page 25 is my grandfather, my lord.
25.
1966, my lord. Village Balapar,
Page 25.
25, my lord.
Are you sure?
Abdul Aziz.
Our page 25 is some a written statement. Although, Mr. Your name,
A.S. Tapadar.
sorry,
A.S. Tapadar.
A.S. Tapadhar refers to the name of the grandfather of the petitioner at page 25, but the page 25 is noticed to be a written statement and not a document containing the name of the grandfather. Petitioner to verify the page numbers and take note accordingly.
Item 17.
Petition, Just check out whether you are referring to the same case number or not.
Item WPC 710. Item 17.
Page 12, my lord,
Page 12,
1966, my lord.
Idris Ali.
Idris Ali and Maimun Nessa, my lord.
Who is Idris Ali?
My father, my lord.
Father is Idris Ali and Maimun is the mother.
Mother.
Very well.
Page 16, my lord.
66, Gaon, Charlock,
Charlock, my lord.
Charlock Gaon. Some Britishers came during pre-independence period of Charlock Gaon. No, there was Charlock Gaon.
It is continuing like this, my lord. In page 16, my lord, can peruse the same name, Charlock Gao. my
No,
lord.
I understand. In Assam, for the villages to have the name Charlock is little unusual. Anyway, Charlock Gaon, then
Page
70 Charlock
16.
Gaon, Idris Ali. And,
Yes, my lord.
and who is the petitioner?
My,
Pierun Nessa, which document?
yes, my lord, 85, my lord.
Page
Page 16, my lord.
16. Okay.
Married in the same village, my lord.
Pierun Nessa.
Now, my lord, I need to come in clean hand before my
Huh?
page 16 was not exhibited, my lord, which I am.
You go and exhibit.
Yes, my lord. This is my respectful prayer, my lord. Hello,
Bring in the, what happened to Idris?
Idris died, my lord. Mother.
The Maimun is Nessa.
My Piarun, there is a small mistake in my name, Piarun and Fiarun, my lord. And from Maimun, it has become Maimun.
It's Maimun, same thing.
I'm deeply obliged, my lord. With that,
My Aru Uiker, it's almost
married in the same village, my lord. Unfortunately, my husband died.
you bring in more material, we'll allow
I'm deeply
it.
obliged.
G. Sharma. The petitioner MUSTP Pierun Nessa had been referred to the foreigners tribunal number. Where is the order?
My lord will find from page 34, my lord. FTD case number 170 of this 2015, my lord.
Had been referred to the foreigners tribunal number 10 Nogao at Doboka for rendering an opinion whether there is a foreigner under the Foreigners Act resulting in registration FTD case number 170/2017. An opinion dated 18/5/2016 rendered declaring the petitioner to be foreigner being aggrieved district petition is instituted. In the writ proceeding, reliance is placed on the voters list of 1966 of village Charlock Gaon, police station Jomunamukh in the Nagaon district, which contains the name of Idris Ali, son of Askar at serial 103 and Maimun Nessa, wife of Idris at serial 104, where both are residing in the same house number 27. The voters list of 1970 of Charlock Gaon also contains same information. Similar information. Petitioner relies on the voters 1985 of village Charlock Gaon, which contains the name of Maimun Nessa, wife of Idris at 316, and that of Fiarun Nessa, wife, daughter of Idris at serial 318, where both are residing in the same house number 118. As the name of Fiarun Nessa appears along with Maimun Nessa, who is shown to be wife of Idris, and the name of Maimun Nessa and Idris appeared together in the voters list of 1966 and 1970 of the same village, Charlock Gaon. It is claimed that the burden under Section 9 of the Foreigners Act 1946 had been discharged by the petitioner. In your remanded back to examine the claim. The petitioner to produce the complete voters list of 1966, 70, and 85 of village Charlock Gaon before the tribunal for its examination. The respondents may also examine as to whether Fiarun Nessa of the 1985 voters list and Pierun Nessa, the writ petitioner, are one and the same person. Submit report. Read orders.
I'm deeply obliged.
Item 19.
May I please your lordship? Lordship, kindly pass over the matter for time being. Seniors in other.
Time being, we are allowing, but most unlikely to come. Because once you get with that other matter, it may take a much longer time.
Item 20.
Yes, item 20.
Earlier
New
order,
Jahan.
Lordship, also.
Marriage register in original government will be produced. You have the marriage?
Yes, Lordship, I don't have, but I have taken this steps, Lordship. But I think some more time may be allowed.
Mr. G. Sharma, like Home Department, prays for some further time to produce the marriage register in original as required by the order of 7/6/2023. List on.
They telephonically informed that they had already communicated to this.
Did go?
17 July. Item 21.
To Sheikh Jafar Ali. Yes,
Wait,
please.
please, Your Lordship. My lord, your lordship will turn to page
Relies on the
page 11,
Sarapara.
66, my lord.
Extra line. Yeah, please. Okay. 73 presented. 73 presented. 73 to 80. 82. Second.
46 to 72 is our shifting. 46 to 72. The rate of shifting is about সারা পড়া পুরো ঠ্যাঙাবাড়ি পুরো সীতাবাড়ি সীতাবাড়ি পুরা রাবাড়ি রাবাড়ি বিদ্যাসের muscle people plus it mass. Quality season right there. Quality season. Depending on me. You're going to run in the secret quality here to let more. A couple for it. After those after that. You learn how to get ideas on the pass. Marks of the look like it. Cultural mind.
Mr. Sheikh.
Your lordship,
Meantime, Khairullah died, name of mother defeated Saharun. If Saharun is another son, and he appeared with Saharun Nessa wife, we require to inform the court of what happened to Sahir Ali in the voters list. I think we passed one order.
your lordship, to clarify that, I have filed an additional affidavit. Because my lord,
Which page?
Sahir Ali.
No,
Yes, my lord.
it's a very complicated equation. Let us understand. Khairullah Sheikh, son of Yaruddin
My lord.
of 1966, village Sarapara.
Yes, my lord.
He is the father
Yes, madam.
of the petitioner.
My lord.
Then shifted from village Harapara
to Tangabari,
to Tangabari,
Tangabari.
Tangabari.
Hello.
Here the
Well, here,
name of Saher Ali, son of Nirula,
well, here your
and
lordship
that
would
of
be pleased to-
Sairannesa, wife of Thirula,
Yes,
where Nirula and Kerula are stated to be same person. Anyway, realizes 77 of Sidhabari. This is again the third village.
my lord,
Name of Jafar Ali, son of Kerula,
my lord. 97 voter list,
97, and Saheren Bewa, wife of Kerula.
my lord. So, my lord,
Where is the name of
Sahir Ali,
Saheron and Kerula together?
my lord. Sahirun Bela,
Saheron Bewa or Saheron Bibi when she was,
Hello.
the husband was alive?
no, your
Where,
lordship,
where is the name of Kerula and Saheron together?
my lord, 66 voter list, my lord,
66, page number.
page number 11, my lord,
Where's the-
page number 11, all for
11,
only for that.
Kerula.
Hmm.
Kerula Sheikh, serial 151.
My lord.
Then where is
Kerula and Sahirun, my lord, together.
Kerula and Saheb Ali? Saheb Ali, son of Kobad,
My lord,
not Kerula, son of Kobad.
may I pointed out one thing, my lord. In last occasion, my lord, in 1979 voter list, page 17. Page 17, my lord, serial number 59 and 61.
Who is it, Nirula and Kerula?
My lord, is Nirullah Kherullah one same person,
Kerula, Nirula,
Same
Kerula,
person.
same person.
same person. Your lordship, Sahir Ali, page 18, my lord. Serial number 59.
No, you
So
forget about your, this thing, Tangabari.
My lord. So your lordship.
So
pointed
you
out-
want to bring Tangabari
My
to
lord.
bring in Sairon.
My lord. So my lord, Sahir Ali was
Sa-
here. So my lord, Sahir Ali remain in Tangabari. That I have clarified in my affidavit.
No, that is only a statement you have made.
My lord, affidavit, my lord.
Affidavit.
And I annex the voter list.
What
of
is an affidavit?
97 voter list, my lord.
Mr. Shea, what is an affidavit?
My lord.
Affidavit is a statement on oath.
My lord, supported by document, my lord.
Which document?
My lord, that 97 voter list, my lord.
How do you know you have to prove it?
My lord.
Come to section 50 of the Evidence Act. How you prove these matters?
My lord, only, I will come to the law, my lord. Later on, your lordship. let us hear
Mr.
about
Sheikh, you
fake,
better come to the law first so that we can hear you in the right direction.
My lord.
If you go on saying something, your clarification statements, it is not helping you in any manner. Ultimately, it is Kerula,
If you-
Kerula Sheikh. You have to prove your link that the father is Kerula Sheikh. You prove it?
My lord. Hirullah Sheikh is my father, my lord.
You prove it.
My lord, 97 voter list may be looked into.
90 page number.
My lord. Page number 21, my lord. Zafar Ali Khirullah Sheikh, my lord.
But that this Kerula Sheikh and the Kerula Sheikh of 1966 are same person.
Same person, my lord.
Show it.
My lord, that is to be same.
That was Siravali. He was in the third place.
That,
Tangabari. Sarabari, there's a Tangabari, there's a Siravali.
my lord.
The
If-
Aru Tangabari Sahib stayed back. Rest of the people went to Siravali.
My lord.
Prove it.
So, my lord, your lordship on another day pointed out to me 1979. voter
That
list.
doesn't matter
Well,
what happened on the other day. That
well,
will not bring any legal right in your favor. Suppose we went wrong on the other day, that will not Make it that you have acquired a legal.
Not wrong, my lord. That was a right direction, my lord. 1979, my lord. That Sahir Ali and Madar appears in 79 voter list. Then your lordship pointed out to me, where is Sahib Ali? The Sahib Ali remained in Tengabari. my
Very
lord,
well, sir.
97 voter list.
Now, this Sairan Nesa and Sahirun Deva, are they the same person?
Yes, my lord. same
How will you
person.
prove it?
My lord, that is my statement, my lord. Otherwise, I am to give evidence on that also.
Give evidence. In fact, Mr. Sheikh, we are inviting evidence from you. We are not preventing you from giving evidence.
My lord, but thing is this, my lord, what I can adduce before your lordship, that only by
Mr.
affidavit.
Sheikh,
Only by
the
affidavit. my lord.
other thing is, we cannot give a judicial pronouncement without appropriate material.
My lord, my humble
Merely on a
submission-
statement.
my
So
humble
this is why
submission-
we are asking you, if you want to give, you give.
My lord, my
If you
humble
don't want to
submission-
give, we'll pass our
my
order.
lord, my humble submission before your lordship, that what I can submit before your lordship, that may be only by affidavit. If your lordship wants that I am to prove it, then matter may be remanded, I will prove that.
Sorry, you bring material before us, show us that this is the material I want to produce, we'll send it back.
Well, your lordship, in that case, my lord, all documents will be looked into, my lord. 1960.
This is not sufficient, Mr. Sheikh. We have already gone through it. This is the second day we are hearing the same matter.
Allah.
It is not sufficient. And how do you prove a relation? Please read sections 50 of the Evidence Act.
Evidence Act I have not brought, my lord. After some time, my lord.
Evidence Act provides for a provision how you prove these matters.
My lord.
Adjourn on the prayer of Mr. M. Sheikh, Land Counsel for the petitioner to explore as to what material may be available to prove that Jafar Ali, son of Khairullah of the Sidhabari voters list of 1997.
1970.
1997 is also the son of Khairullah Sheikh of the 1966 voters list of village Sarapara.
List capture, my lord.
Anytime you want.
2 weeks, 3 weeks like this.
Take the date, whichever date
Yes.
you want.
3 weeks.
3 weeks. please.
Oblige, your lordship.
Item 22.
May I please, your lordship?
Complete voters list of,
I have brought it.
got it. What does it say?
Lordship, the petitioner claims himself to be the son of Asar Ali and his mother's name is, your lordship, Koriman Nessa. In 1966 voter list, your lordship, serial number 99, his father's name appears, Asar Ali, and serial number 101, Koriman Nessa, in village Posim Damlong. Therefore, your lordship, in voter list of 1970, again in serial number 99, Asar Ali, and in 101, Koriman Nessa, your lordship. Therefore, in 1997 voter list, your lordship, in page number 5, I have made a small fold, your lordship, I have highlighted it. Serial number 451 is Asar Ali, house number 148, and 452 is Koriman Nessa, and therefore in 462 is Zoinuddin Pita Asar Ali. His name is J along with the family of this. Same village. of us.
Let's go back. Heard Mr. I would be Land Counsel for the petitioner also heard. The petitioner Jainuddin had been referred to the
Page 26.
the Foreigners Terminal number 7 Nogao at Lanka. Is there any opinion as to whether he is a foreigner under the Foreigners Act? FG stroke L case number 339 2016. Opinion dated 10/11/2010 declaring him to be a foreigner, being agreed list of petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1966 of village Poschim Dablong, Moza Lanka in police station Lanka, Moza Lanka in the Nagaon in the present Hojai district, which contains the name of Asar Ali, son of Mofizuddin at serial 99 and that of Fateh Jan, wife of Mofizuddin at serial 100. It is claimed that Asar Ali is the father and Fateh Jan is the mother of the petitioner.
Koriman Nesai. 101 is Koriman Nesai.
Acha, not Fateh Jan. Mofizuddin and Koriman Nessa, wife of Asar Ali at serial 101. Claimed that Fateh father, Koriman mother. Reliance is also placed on the voters list of 1970 of village Dablong, Pub Dablong, Postim Dablong, containing the name of Asar Ali at serial 99 and Koriman Nessa at serial 101, where both are shown to be residing in the same house number 25. Further reliance is placed on the voters list of
97.
what happened to your fold? Oh, not really. Of 1997 of village Postim Dablong, which contains the name of Asar Ali, son of Mofiz at serial 451, Kariman Nessa, wife of Asar at serial 452, and that of Jainuddin, son of Asar at serial 462, where all of them are shown to be residing in the same house number 148. It is claimed that Jainuddin is the writ petitioner himself, and as his name appears along with Asar Ali and Kariman Nessa in the voters list of 1997 of village Postim Dablong, where the names of Asar Ali and Kariman Nessa together also appears in the voters list of 1966 and 1970 of village Postim Dablong. Petitioner had discharged the burden under the view of the remand back to examine the voters list. The small home department may make their verification as to whether Jainuddin of the 1997 voters list of village Postim Dablong and the writ petitioner Jainuddin are one and the same person. The voters list provided by Mr. A. Ali, then counsel for the election commission is returned. What do you say? Is retained on records.
Item 23.
If you want, you can take certificate copy of this one and go also complete one. Right? I go to Palova. 23. Suresh Biswas. Who is the another?
In this case,
No, who is the another?
another his wife.
Wife is
The-
another.
Check the record. There was no reference against the wife.
Lordship, we need to go through the record, Lordship. We'll fix it up next week, Lordship. And
Adjourn on the
Lordship,
prayer of MSA Verma and Home Department to enable the land council to examine the records.
Diploma.
Item 24.
Either early.
My lord, it's a contested case on the previous voter list of 1961 of parents, my lord, at page 34.
34.
Vernacular at 35. Father's name is Kismat Ali.
Kismat Ali, father.
Father. Hazira Khatun, mother.
There are
Gofur Ali, Hamed Ali, their paternal. uncles. Village, my lord, Bhukuam Ali.
father, Hazira mother, village Phokuamari, Soigao.
My lord.
And who is the petitioner?
Petitioner lordship will find in the voter list of 85 at page 44,
Page number.
page 44, my lord. Vernacular page 45.
Petitioner Haider.
Hyder Ali. In same village, my lord. the subsequent voter list also 97, 2005. with
But
parents.
the age difference between Haider and Hazira appears to be
My lord,
very less.
that is a mistake, my lord, in the voter
Okay, we'll
list. my
send
lord.
it
So
back.
there-
We'll ask the tribunal to examine this aspect.
My lord.
Why the,
Other voter list are there, there is the discrepancy is not there, my lord. Maybe, my lord, in 85 voter list, there may be some discrepancy.
Lordship may send it back, the tribunal may examine it.
heard Mr. A.S. Shidal and counsel for the petitioner also heard the petitioner Haider Ali had been referred to the foreigners tribunal number. Where is the order of the
Page
tribunal?
81, my lord. Page 81. My lord, the reason assigned is that why not certified copy of the NRC legacy data? And my lord, there is some minor discrepancy of grandfather's name, Toripullah and Torifullah. And the voter list of 85 name is discrepancy. These are the reasons has been.
Resulting in registration of vehicle. GFT bracket R case number 318/2017. Rendered an opinion dated declaring to be a foreigner dated 15/6/2018. In the root proceeding, reliance is placed on the voters list of 1961 of village Bhokuamari Police Station, Soigao, Moza, Pup, Samoria in the Kamrup district, which contains the name of Muhammad Kismat Ali, son of Toribullah at serial 105, and that of Hajira Khatun, wife of Kismat at 106. And both are shown to be residing in the same house number 20. Reliance is also placed on a voters list of 1966 of village Bhokuamari, containing name of Kismat Ali, son of Torifullah, at serial 171, Hajira Khatun, wife of Kismat at 172. And both are residing in house number 54. Further reference is made to the vote 1960-70, containing name of Kismat Ali and Hajira, where both are residing in the same house number 54. 70 of Bhokuamari. Thereupon, reliance is placed on the voters list of 1985 of village Bhokuamari, containing the name of Kismat Ali, son of Toribullah at serial 24, Hajira Khatun, son, wife of Kismat at 25, and Haider Ali, son of Kismat at 26, where all three are residing in the same house number 85. It is claimed that Haider Ali is the petitioner, Haider Ali of the 85 voters list to the petitioner himself, and his name appears along with Kismat Ali and Hajira Khatun, whereas the names of Kismat Ali and Hajira Khatun also appeared in the voters list of 1961, 1966, and 1970 of village Bhokuamari, and therefore he discharged the burden under section 9. Full stop. In view of the, it has been stated that the tribunal had rejected the aforesaid voters list by providing a reason that in some voters list, the name of the father of Kismat Ali is shown as Toribullah, and in another it is shown as Torifullah. The tribunal is reminded that the Supreme Court in its decision is, where is Kamatullah and Karafullah?
Yes, Sirajul Haq case.
In Sirajul Haq
2019
versus Union of Indian Others, reported in
2019 5 SCC.
2000,
2019
19, 5 SCC
534.
534 had clarified the said aspect that a minor difference in the spelling of a name should not be constituted to be a reason to dismiss a claim by a proceeding. Upon examining that a reason already passed, the respondents in the Home Department may make their own inquiry as to whether Haider Ali of the 1985 voters list of village Bhokuamari and Haider Ali, the present writ petition, are one and the same person. They have to file report upon doing the needful reason already passed.
Lovely. My lord, I have another matter, item 19. my lord. Just password for timing.
Ask somebody, let the item be called.
My
we'll do
lord,
it.
my-
Item 25.
Time being. Pass it for time being.
timing.
You are going somewhere.
No, my lord. Already password for the time being. Password for time.
No, why do you want timing?
No.
I was in leg on other.
Oh, 19 is already past timing.
My lord.
Mhm. But we don't know, Mr. Sikdar, whether those timing matters can be accommodated today,
Yes, my
because that parted series is there.
my lord. After.
If that one starts,
If
the
not
way
possible-
arguments are advanced, it may
Yes.
take a longer time.
Okay. Okay.
And if it does not, definitely
My
we'll
lord,
take it up.
after application.
Mahendra Corporate.
Actually, I think we will come. I think we will come. Yes, Madam Ghosh.
May I please, your lordship, in this case, if I'm accommodated today, one reason is that because there were two references against this
If
person.
you are accommodated today, what will happen tomorrow?
No, I have to just get the instruction from the
You-
client.
Tomorrow we'll get some instruction.
No, I just want to talk to the client once. Reason, there is two references in two districts. And both of them, one reference were in Kamrup Metro District where he has filed WS written statement. And there was an ex parte order in Morigao District. Morigao District, this honorable court was pleased to set aside the ex parte order and remand the matter back
Okay.
before the tribunal.
Now, where do you want to contest?
So I hear already the matter.
No,
is
no,
evidence.
you want to contest a matter in Morigao or in Kamrup?
I want to get the update of Morigao case from the
No,
client.
no,
In Kamrup,
you want to contest in Kamrup.
Kamrup.
We'll,
And this is the
we'll
matter.
interfere with Morigao, we allow you to contest in Kamrup.
Yes. And whether that matter is disposed of or not, then I'm not sure. This is the reason I just need to talk to client once.
That is fair enough.
She can always come back next week, no,
Huh.
Monday, lordship.
So
With
if
this
the
information.
references are against the same person in two different places,
Yes,
you
Lordship.
choose between the two,
Yes, Lordship.
whichever.
One, this court has already interfered and sent it back. One is going on and the other one is still, she's before this court for the other one.
For Kamrup.
Kamrup. So Kamrup evidence already being filed also.
Why are you here before the court for
Because in
Kamrup matter?
two district, two references, two
That is
cases.
the only
It's
reason.
contested
Yes.
in
Don't
both,
worry,
lordship.
Yes, Lordship.
your client will be protected.
Yes, Lordship.
You choose which of the two places you want to contest,
Kamrup Metro.
Kamrup. So we'll
Yes.
interfere with the other one, require you to go and appear in Kamrup, prove your
Kamrup,
citizenship.
it is already going on. It's in the evidence stage, lordship.
Yes, Lordship.
You go and prove it, other one will interfere, if it is the same person.
No, let her complete the Kamrup first and then with this opinion, she can go and get that matter closed in Morigao lordship. Because it will otherwise.
No,
both the
may I
matters-
submit, Lordship?
Madam Verma, it is not on convenience, it is a non-maintainability. Under the law, two cases are not maintainable against us.
Club together that Morigao one.
There's,
can-
we cannot club also.
Because it's.
Only way is interference. I think it will be covered by section 9 of the CPC. 9,
Check.
11, second proceeding has to be stayed.
CPC मेरा पैड में है. Then,
Second proceeding is not maintainable. I think 9,
then,
9 or 10 of the CPC. just check.
Not.
Stay of suit 10.
10.
Instructions.
So you, MSD Ghosh and other petitioner states that against the same petitioner, two proceedings had been initiated, one at Kamrup Metro and another at Morigao. And an adjournment is sought for to provide the details of the two proceedings. This one says.
Deep privilege.
26.
I file additional evidence.
Filed, already filed.
Here, my lord,
Why did you file?
because of the fact that in 1966 voter list, my lord, I am relying upon the name of my paternal uncle.
Abdul Halim. 70, my father's name is there, but 60 is not. So in this code wanted to know whether there is a subsequent voter list. My father's name along with Abdul Halim is there. That I have annexed, my lord. In additional affidavit, my lord kindly peruse page 77, annexure B.
Mr. Uddin, how authentic and correct is your statement in this court? You said this court wanted to do something. How correct is that statement?
Ask me to clarify.
How correct is the words this court? Forget about asked and not asked.
Honorable court.
Uh,
I'm sorry, my lord, because of
how correct is the expression this court?
that should be, my lord, is honorable court.
No, we are not on honor. Or the expression this court.
This may not be there.
That expression is not available. You can say the court.
I am obliged. In future, I will be careful. My lord, kindly peruse.
Hmm.
First, my lord, my
Page number?
writ petition.
Uh-huh.
Page 17 of my petition, main petition.
17. What is
Then, my
17?
lord, additional evidence point will be clear.
Hmm.
Page 17.
17, 18 is the vernacular?
Yes, ma'am. This is Halimuddin.
Halem.
Halimuddin, my paternal uncle.
Hmm. So elaborate on the father.
Yes, ma'am. And page 719, that is
Hmm.
Amjad Ali is my father.
Page 19. Amjad Ali is the father.
Is my father.
Hmm.
And page 21, Aitun Nessa, my mother. Both 71.
Yeah.
So I exhibited during the trial the voter list of 66 where paternal uncle.
No,
name
that is okay.
in addition,
Amjad is the father.
one.
Which document would show Amjad is the father of Mujida?
That this your lordship kindly find. There is a my lord Namjari order, mutation order.
Page number.
Page my lord 32. Annexure 8. So here, my lord, my name along with my lord sister and brothers mutated in place of my father, Amjad Ali. Page 30. This document exhibited as exhibit
Hmm.
9.
Mujida.
Yes, sir.
The land is in which place? Village. Some Khaiti, Kaso Khaiti.
Kasuvai.
And this voters list is a village, Kaso Khaiti.
Kasuvai. Same.
Yes, Mr. Sharma, what do you do?
Lordship remand.
Hmm.
Lordship remanded.
Where is the name of Azmat?
Azmat is page 7, my lord 77 good only.
No. In Jamabandi,
Jamabandi, your lordship. It is as per order.
serial number.
Page 35, your lordship.
Where do you get Azmot? Azmot.
48.
33.
Yes.
And where is the name of what did you say? Mozida?
That is below, my lord, page 35. There is two note below.
Hmm.
4/8/2017 তারিখৰ নামজাৰি
No, Namjari will see. Azmot is there. Where is the name of Mozida?
আজমতৰ স্থলত হবিবুৰ ৰহমান, মজিদা খাতুন, মৃত আমজদ আৰু মাজেদা খাতুন। মাজেদা খাতুন, আমজদ আৰু মজিনা খাতুন,
ইয়াতে Mozida নাম
মুছাম্মাদ আইতুন নেছা
Azmot
নামত নামজাৰি কৰা হ'ল।
Mozidaর নাম কত?
মাজেদা খাতুন।
Where did you, where are you reading? Mazeda.
Yes, page
I
35.
think serial number 49,
Yes, ma'am.
37. The petitioner, Mazida Khatun had been referred to the foreigner's tribunal number
59 page.
P, Nogao, for rendering opinion as to whether she is a foreigner within the meaning of Foreigners Act 1946, resulting in FT case to page 259 of the same. Opinion dated 11/3 declaring the writ proceeding reliance is placed on the voters list of 1965 of village Kasokhaiti, which contains the name of Halimuddin, son of Jamiruddin at serial 268. It is stated that Halimuddin is the elder brother of the father of the petitioner. Further reference is made on the voters list of 1971 of village Kasokhaiti containing the name of Ajmat Ali, son of Jamiruddin at serial 707, and that of Aiton Nessa, wife of Amjad Ali at serial 708, where both are residing in the same house number 109. It is claimed that Amjad Ali is the father of the petitioner. To substantiate the same, reliance is placed on the Jamabandi of a plot of land at village Kasokhaiti, which contains the information that, where is the order of the circle officer? Contains the information that by the order of the circle officer dated 4/8/2017 in mutation case number NAG 17, page 35 would I say. The names of, amongst others, Majida Khatun, daughter of late Amjad, had been mutated in place of Amjad. And accordingly, their names had been entered in the Jamabandi by deleting the name of Amjad, her name. Full stop. Accordingly, it is claimed that discharge burden on the line had been discharged. That remand back to the tribunal to examine the voters 65, 71 of village Kasokhaiti as well as the Jamabandi of the plot of land of village Jamabandi. The petitioner to produce the complete order of the circle officer dated 4/8/27 for examination of the tribunal. And the responding Home Department to make an inquiry on the authenticity and acceptability of the voters list as well as the in the Jamabandi. So, a verification be also made as to whether Majida, what is full name? Majida Khatun at serial 49 of the Jamabandi and the writ petition Majida Khatun are one and same, and with the needful reason order be passed. Yes, Mr. Mujumdar, that matter, what we do, it was called as you and Mr. Chaudhary were not there, we passed it over.
Reservation matters.
None.
Legal.
Oh, yes.
So far as we are concerned, one affidavit we have filed.
Have you seen that affidavit?
Well,
Okay.
Lordship have possibly heard the matter, otherwise.
Otherwise, does Mr. Chaudhary has to say something or?
Chaudhary, I have not met him.
Well,
My lord, I shall inform him that if he has got.
inform me if he wants to say something, let him come. Otherwise, we keep it for
My lord.
next Friday. Let us see what we do.
My lord, I'll just inform him.
But if he comes, we'll hear him. If he does not come, next Friday. we will.
My lord.
Item 27.
Lakshman Kumar Roy
Roy, my lord.
relies on the 96 and 70 of village Boroibari. That is the name of Ganga Prasad Sarkar.
Subsequently, they started writing surname is Roy, madam. My lord, the president of Borobari Gaon Panchayat given a certificate. madam.
Where is the permanent residence certificate?
My lord, initially they were Borobari Part 3, PS Gauripur District Dhubri. So
No,
subsequently, my lord, they
Page
Borobari,
number. Page
my lord,
number.
that is stated in
Not stated. Where is that certificate? Permanent residence certificate.
TRC, that is, no, my lord. That is in the LCR, my lord. LCR page number 70, my lord.
LCR page number
70, my lord.
17.
My lord. It was exhibited at exhibit number 9.
Seventeen is some statement of something. It is half town, half
70, my lord.
70.
70.
But this is of 86.
Deputy Commissioner, yes, my lord.
Boroibari. Village is same, no?
For sure.
Village one same. 86 or it Ganga Prasad Roy. Aru voter is Ganga Prasad Sarkar. So last time we passed an order, produce any material that Sarkar and Roy, they are the same person.
Lordship, the president of Borobari Gaon Panchayat has given a certificate, my lord.
The president of Boroibari Gaon Panchayat had issued a certificate dated 19/6/2023, certifying that the father's name of Lakshman Kumar Roy had been recorded in the voters list of 1966 and 1970 of village Boroibari as Ganga Prasad Sarkar. But in other relevant documents and papers, including the permanent residence certificate, the name is shown as Ganga Prasad Roy, and therefore it was certified that Ganga Prasad Roy and Ganga Prasad Sarkar are one and the same person. The president Boroibari Gram Panchayat to file an affidavit before the court stating his source of knowledge as to why he states that Ganga Prasad Sarkar and Ganga Prasad Roy are one and the same person. A copy of this order be made available to Nagasan for the PNRD for, oh no, Gram Panchayat, Gram Panchayat PNRD for doing the needful. The copy of the certificate issued by the president is kept on record.
But may I take a Xerox of this? Today morning only just copy is handed over my now.
It will Xerox set up retain could origin returning back.
Lost.
And for a copy of the certificate is kept on record while the original is returned back to Mr.
Lost.
Chanda. Could for a new certificate on
Initially, my lord, there was a proceeding against her mother also. But in her mother's case, she is declared an Indian citizen. My lord. I have also annexed this copy of along with this petition. My lord.
Do you follow matriarchal society?
My lord.
Do you follow the matriarchal system? Does this family follow the matriarchal system? No. Then your mother's citizenship is not much of relevance. She may be a citizen. Sorry. Take up the microphone, maybe.
Lordship, 1 week time will be granted to file additional affidavit.
What additional affidavit?
Lordship, on the last occasion, we are directed to show
Hmm.
that Mukshed Ali of village Haldia Gaon and Mukshed Ali.
So petitioner to show that Mukshed Devani of the Bheragaon and Mukshed son of Janab of Haldia Pathar.
Not additional affidavit.
What will you do in the additional affidavit?
Lordship, the petitioner's father's name appeared in the voter list of 1966, Lordship.
Now we have recorded that 66 Haldia Pathar,
Lordship,
Mukshed Ali son of Janab,
Lordship, we are.
and Jamabandi of village Bheragaon,
Lordship,
Hasina daughter of Mukshed.
Lordship. Lordship, they have purchased a land of village Bheragaon, Lordship, but Mukshed Ali is shown to be a resident of village Haldia Pathar even in the Jamabandi, Lordship.
Bring a sale deed of that purchase deed or sale deed of that land at Bheragaon. If Mukshed of Haldia Pathar had purchased land in Bheragaon, you can establish the thing.
Lordship.
That with the original. 1960.
Is it okay?
Lordship, and the petitioner's mother, stepmother, brothers, they are still residing at village Haldia Pathar, Lordship.
Petitioner's mother.
Mother, Lordship.
Then who shifted to Bheragaon?
Lordship, they have purchased a land at Bheragaon, Lordship.
Okay,
They
you
are still
only
residing
purchased the
at
land.
Haldia Pathar,
It
Lordship.
is stated that Mukshed Ali, son of Janab, whose name appears in the 1966 voters list of village Halodia Pathar of Borpeta district, had purchased a plot of land at village Bheragaon. And the name of the petitioner had been mutated in place of Mukshed Ali in respect of the plot of land at village Bheragaon. To establish that Mukshed Ali of Halodia Pathar and Mukshed Ali who purchased land at Bheragaon are one and the same person, the sale deed of the purchase be produced before the court. We want to see if Mukshed of Halodia Pathar had purchased,
Lordship.
I think you are true. But if Mukshed of Bheragaon had purchased, then again,
Lordship.
you'll have to produce something more.
Lordship.
origin a photocopy to you. The origin of the 1966 photo which are produced be returned back by retaining a photocopy of the same for the recovery.
Acknowledged, Lordship.
Item 29.
May I please, Lordship?
29 years. Sobiron Nessa,
Lordship, Sovereign Nessa is the petitioner, Lordship.
who is the father of Sobiron Nessa?
Lordship, page 20, Lordship.
20.
Barnacular page 21. Lordship.
Izatul Bewa
There was
is the
mother,
father.
Mother. And
Fidis Ali is the
Fidis
father.
Ali brother,
Huh?
brother.
Brother.
He is the DW2.
Who is the father?
The Danish Sarkar.
Danesh
Sarkar,
Sarkar is the father.
father. He's died before 66.
Petitioner is Sobiron.
Fidis Ali is the DW2. Fidis Ali brother, Lordship, he is the DW2.
Where is which page?
His Lordship 50 B, Lordship.
Sorry,
50, 50.
50.
Lordship. Type to be 50, Lord. Type to be 50.
DW2
So, Lord.
54 page number.
Lordship, 50. Type to. Type, no?
He is of village Niz Bagbor and the Fidis Ali is a resident of village Dologao.
The shifting, Lord.
If it is shifting, what will you have to do now?
Due to reason, Lordship. Brahmaputra, Lordship.
The petitioner relies upon the voters list of 1966 of village Dologao, which contains a name of Fidis Ali, son of Danesh Sarkar at serial 165. It is claimed that Fidis Ali is the elder brother of the petitioner. Accordingly, reliance is placed on the evidence of DW2 Fidis Ali, son of Danesh Sarkar. But it is noticed that DW2 Fidis Ali is of village Niz Bagbor, whereas Fidis Ali of the 1966 voters list is of village Dologao. Mr. N. Ahmed, the council petitioner, seeks to explain that the family had shifted from village Dologao to Niz Bagbor. Any relevant material as may be available to establish the shifting may be produced before the court.
Master.
Item 40.
Yes, 30.
Yes.
Hmm.
Father's name appeared
Mul Kusum Begum. Where is the father?
46 page number, Lordship.
46. Village is Boguriguri,
Buguri Pata.
Pothar, Borpeta Hodor, 70.
Moni Mondal.
Who is Monimontal? Father.
Father.
Which
Then
document will
70
show
voters
Monimontal is the father?
A document is page 58 Jamabandi, Lordship, and brother has adduced evidence, Lordship, and brother and father together in 85 voters list. And 85
Sorry, Jamabandi page number.
Jamabandi is page 58, Lordship. Lordship, with the record, it's more clear. Jamapandi. Serial 14, Mool Kusum.
কোন গাঁৱৰে হয় মণি মণ্ডলৰ জেগাত ফুল কুসুম মূল কুসুম গাঁওখন একে and 85 which page
85 page 50.
Hmm.
50 Lordship.
85 what is this page 50
Yes, Lordship. Boguri Guri Pathan.
Momin Mandal
And
who is the brother
Mogbul. Brother is 220 Lordship.
Mogbul
Mogbul Hussain.
and Mogbul had rendered evidence.
Yes, Lordship.
Yes, Mr. Sharma, what do you say?
Lordship, in 1966 footer list, Lordship,
Moni to Momi. Moni to
father's name appears as Moni Mondal Lordship. 66 and 70 Lordship.
Ata.
It's hot.
Ato. Momin Mandal.
In 1965 footer list. 65 and 70. Lord.
Moni and Momin, same person.
There are else discrepancy.
M. Momin Mandal Lordship. Is
No.
M. Momin Mandal.
That's why I'm asking. Is Moni Mandal and M. Momin Mandal same person?
Yes, Lordship. And village also is same. And even this Jamapandi Lordship.
And Ata and Atab are also same person.
Atab, if we call for the original records, might be written as Atab. Sometimes while this is a digital voters list, while typing, they might have done the mistake, Lordship. If original is called for, it might be Atab. And
You prove it, Mr.
and
Let them go back to the tribunal and prove it. We'll keep this question open.
yes, Lordship. Yes, Lordship.
Yes.
And Lordship, even this land which the father's name was mutated in 75, the Latmandal in his evidence also had stated.
We are since some time we are thinking of asking a question.
Yes, Lordship.
Why all the mutations are taking place around 2018? Whenever the relationship is sought to be established by means of an order of mutation, almost invariably,
Yes,
the
Lordship.
mutation orders are of the year 2018. That is, after the reference had been made,
Yes, Lordship.
or when the reference is about to be made.
Yes, Lordship.
Is it a case that all the fathers, they died only around the year 2018?
No, Lordship. If I say, if I say my father died in 2009, but till date we have not mutated as legal heirs of his
That is
sons
okay
and
in your
daughters.
personal case, but at least you have not chosen 2018 to do it.
Might be because these are the poor people, they don't have any other
Understand.
linkage, Lordship.
So,
If I have to
so if
prove
you are
my
a
relationship
poor
with my
people,
father,
you
no.
choose the year 2018 to do the mutation. If you are not a poor people, you may not do it also, or you may do it at any other time. We are asking you the relevance of the year 2018. Almost invariably, mutation orders are of the year 2018. And we must have examined a minimum 100
Yes.
to 200 of these mutation orders till now.
Yes.
Why the mutation could not have taken place in any other year? Mhm.
We have to ask the parties.
2018. no?
But
Reference given. Lordship yesterday had mentioned about the pendency high. Lordship had yesterday mentioned about the high pendency of 17, 18, 19. It was at that time the NRC process had started, Lordship. Many people over the years who had these orders, they had never contested. So during the NRC, they thought that that would be the only document because it was the National Register of Citizens.
So
Every
go
person
and
can-
get yourself
Yes,
the
Lordship. The
mutation. done.
flooded with 60, 65 matters every day. Because everyone wanted their names to get registered in the NRC Lordship. So if Lordship will look into the opinions of 17, 18, it is mostly a very old opinions, Lordship, 2007, 8, 12. Even after obtaining the opinions, everyone was sitting silent. But when NRC process started and they knew that they had to submit
So the number of filing was more.
humorous, Lordship, it was like
But it did not come
Unexpected.
of any aid if the matters are still pending.
it's a filed in 21, Lordship. This case was filed. in
I'm not on
21.
your case.
I'm
These
just
are
a general
substantive.
observation, and this one, this police reference is of 2012, 8, Lordship, 8. I don't know, is this?
So is the NRC also a reason why most of the mutation orders
Yes.
referred are of 2018?
And even
2018, suddenly there's a rush everywhere.
boom everywhere, Lordship of documents, even the panchayat certificates. Because people were, the family tree had to be scientifically, it was prepared scientifically, it had to be verified. So during the NRC, in one family, since they used, my father was in Dhubri, and then he shifted to Hojai, they crisscross, Lordship. And when they came to the NRC Seva Kendras, one person had 200 family members in his name. But when they reached there, none of them knew each other. They only used the documents, but physically these people were not even known to each other. So
But
that,
NRC, they adopted a very good method.
it was a very scientific
Suppose
method, Lordship.
B is relying on some relative somewhere,
That one also.
then
has to be done
no,
this one.
which shows that A is a relative.
Yes, Lordship.
You also examine what A is saying. A may not say that B is his relative.
That is.
So
how-
that the thing can be detected from that point of
There
view.
was lot of hue and cry because people were. made to know-
Suppose Madam Ghosh now comes and makes a claim that Madam Verma is her relative in her documents.
I will also.
If
have
the
to-
document of Madam Verma doesn't indicate that Madam Ghosh is her relative, then that claim falls through.
Yes.
It was a very good
So that is why that family.
method of
tree-
cross-checking.
Yes. And in many districts, Lordship, one man had about 10 families to his name. One grandfather or father had about 10 families to his name. One in
So
Hojai, one in
that
Lanka.
grandfather in heaven must be very proud.
Since I was the NRC council at that point of time, we came to know about so many things.
So that's why 2018 mutations.
18.
Maybe possible.
And most of the epics were of 2013, the voter ID cards.
Yes, what do you want to do? You prove Moni Mandal and Momin Mandal same person, Ata hai and Atabar same person. Otherwise, we are sending it back. But this you'll have to bring in more specific material. MSD could not. The petitioner MUSSTT Mulkusum Begum had been referred to the
Foreigners Tribunal 11, Lordship.
Foreigners Tribunal number
Borpeta. Number 11, Borpeta.
11 Borpeta for rendering an
860.
opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of case number so and so. Case number huh? Tribunal rendered an opinion dated declaring being aggrieved district petition. In the writ proceeding, reliance is placed on the voters list of 1970 of village Boguri Guri Pothar, Moza Kharida Bizni in the present Borpeta district, which contains the name of Moni Mondal, son of Atta, at serial 304. Reliance is also placed on the voters list of village Boguri Guri Pothar of 1985, which contains the name of M. Momin Mondal, son of Atab, at serial 216, and that of M. Makbul Hussain, son of Momin, at serial 220. It is claimed that M. Momin Mondal or Momin Mondal of the 85 voters list, or Moni Mondal of the 1970 voters list is the father of the petitioner, and M. Makbul Hussain of the 85 voters list is the brother. M. Makbul Hussain had rendered evidence as DW
3, Lordship.
as DW3 before the tribunal, stating that MUSTT Mulkusum Begum is his sister, being the daughter of his sister. A Jamabandi in respect of a plot of land at village Boguri Pothar is also relied upon, which refers to an order of the circle officer dated 17/7/2018 in mutation case number page 58, which contains the information that, amongst others, the name of Mulkusum, daughter of Momin Mondal, had been mutated in place of Momin Mondal. By relying upon the information contained in the Jamabandi, and also the evidence of DW2, where the name of DW2 is claimed to be appearing along with M. Momin Mondal in the voters list of 85, where the name of Moni Mondal appears in the voters list of 1966 of village Boguri Guri Pothar. It is claimed that burden under section 9 had been discharged by the petitioner. View of the above, remanded back to examine the voters list of 6685 of village Boguri Guri Pothar, as well as the Jamabandi of the land at village Boguri Guri Pothar, and pass a reasoned order thereon. The petitioner to produce the complete order of the circle officer dated 17/7/2018. Petitioner to also produce relevant material before the tribunal, which may show that Moni Mondal of the 1966 voters list of village Boguri Guri Pothar and M. Momin Mondal of the same village of the 1985 voters list are one and the same person. And also that father of Moni Mondal, namely Atta, and father of M. Momin Mondal, namely Atab, are also one and the same person.
They also can verify, Lordship.
Uh-huh.
Border also can verify.
The Home Department may also make their own verification and submit report before the tribunal.
Lordship. And 66 and 70.
66 and 70.
Deeply old, like Lordship.
Most likely it is yes, but still.
Yes, Lordship. And if complete list also is there, that also can be corroborated. with-
You can produce the complete
Complete
list in origin also instead of all these extracted copies.
Yes, Lordship. then also it.
The
will be-
origin voters list may contain the correct name.
Yes, yes.
Item 31,
31.
Lordship,
That's your-
father of the
It is share. This is your share. Sahit Annesa, who is the
father
father?
of the petitioner is Tajuddin alias Raizuddin. Raizuddin is the actual name, but in some voters list, Tajuddin appeared, Lordship. Or page 53, Lordship. Voters list of 1956.
53. Taiz Uddin, son of Busa Mondal.
Yes.
He is the father.
Yes.
This is of 1966.
Yes.
Kolgasia.
Page 55, Lordship.
55. Taizuddin, same Taizuddin, father.
Lordship 505,
Uh,
serial number is Hakimuddin.
70, sorry.
Lordship in page 55, Lordship.
Uh,
Serial number 505, Hakimuddin. Hakimuddin come in.
Hakimuddin.
Yes, Lordship.
Who is Hakimuddin?
He is the brother of the petitioner.
Brother.
Lordship.
Okay. Did Hakimuddin depose?
Yes, Lordship. Page
SDW,
40 SDW2,
page number?
48, Lordship.
The problem is Raizuddin and Taizuddin.
Yes. Same village, Lordship.
But Basatan name is common, I think, no? In both.
No, Lordship. 66 only
Oh,
Taijuddin
Taizuddin
is
no.
there.
Examine. Same order like the previous one. You also proved that Taizuddin, Raizuddin are same person.
Lordship, one land document is there, Chitta.
Hmm?
Chitta of 58-59 of the year 58-59 is there, wherein the name of Raijuddin is mentioned, Lordship.
But that not will make Taizuddin of 66 to be Raizuddin.
But grandfather's name is same, Lordship. If we see the voters list of 1966 and 70.
You place this matter before the tribunal.
Yes, Lordship.
We instead of we taking a call.
Yes.
Yes, Mr. G. Sharma, what did you? Heard MS.H. Betalal and counsel for the petitioner also heard. Sahit Annesa had been referred to the foreigners tribunal number
Which 35, Lordship.
11 Borpeta for rendering an opinion as to whether she's a person, she's a foreigner under the Foreigners Act 1946, resulting in registration of case number BPT/11 bracket close FT 807-2016. Tribunal rendered an opinion dated 22/1/2021 declaring the petitioner to be a foreigner. Being aggrieved, district petition is instituted. In the writ proceeding, reliance is placed on the voters list of 1966 of village Kolgasia, Moza, Rupsi in the Borpeta district, which contains the name of Taizuddin, son of Busa Mondal at serial 414, as well as the voters list of 1970 of village Kolgosia, which contains the name of Taizuddin, son of Busa Mondal at serial 503, Basatan Nesa, wife of Taizuddin at serial 504, and Hakimuddin, son of Taizuddin at serial 505. Taizuddin is claimed to be the father, while Hakimuddin is claimed to be the brother of the petitioner. Hakimuddin rendered evidence before the tribunal as DW2, wherein he states that the petitioner Sahitan Nesa is his brother. But it is noticed that DW2 is Hakimuddin, son of Raisuddin of village Kalgasia. Whereas the voters list of 1966 is of Taizuddin. Reference is also made to some Chitha
Yes, Lord.
of the year 1958 of
58,
Kalgasia,
Yes.
which contains a name of Raizuddin. It is sought to be clarified that Taizuddin of the 1966 and 1970 voters list and Raizuddin being the father of DW2 as well as Raizuddin of the Chitha of 1958 are in fact one and the same person. Circumstance remanded back to examine the voters list of 1966 and 70 of village Kolgosia. The petitioner may also produce any relevant material which may prove that Taizuddin of the 1966 and 1970 voters list of village Kolgosia and Raizuddin being the father of DW2 and who is also referred in the Chitha of 1958 of the land at village Kolgosia are one and the same person. Upon doing the needful regional Home Department may make their own verification submit report.
After 1970 lordship.
Sorry.
Also after 1970 lordship, what happened to Taijuddin? Nowhere it was mentioned lordship. No voter list has been placed
The-
lordship.
The petitioners for examination code may also produce the complete voters list of village Kolgosia of the years 1966, 70, 77, and 85 for examination. This complete list is always for your benefit. Although somebody may feel that's a trouble in taking it out, but in most cases we find it ultimately helps you only.
They filed one title suit also, Lordship, wherein. the
Divorce suit.
legal Also there,
Who had filed divorce suit?
title suit, Lordship,
Title suit. But who?
brothers of the petitioner.
Hakimuddin.
Yes, Lordship, page 77, Lordship,
Title suit for what purpose?
because right title interest, they have filed it and the name of the Saritan, the petitioner is also mentioned, Lordship.
Sorry.
Name of the petitioner is also mentioned.
What you saying? Name of the?
Lordship, page 77,
What is it?
title,
Title suit by Hakimuddin for what purpose?
for the right of the.
Over some land.
Yes, Lord.
Against whom?
Here also lordship, legal here some Riajuddin Mondal.
Yes, I already stated Tajuddin and Riajuddin. There is.
So
a
she is trying
discrepancy.
to show that Riajuddin is the actual father.
Yes, sir.
Tajuddin was wrongly recorded. Possibly that is what is being projected. A title suit filed by Hakimuddin, son of Riazuddin, is also referred. Page 70. Page number 70.
77, Lordship.
77. तो लीजिए कोई वहाँ that Hakimuddin কি বলো son of Raizuddin
Yes, Lordship.
of village Kalgosia.
Yes, Lordship.
Read the complete sentence. The bearing title suit number 35/2017 in the court of Munsif number 1 Borpeta is also referred to show that the name of the father is actually Raizuddin and not Taizuddin. The materials from the title suit may also be referred before the tribunal to establish the same.
Item 32.
Tomba Paul.
May I please, your lordship? Father is
Page, father is page,
Baidyanath Pal,
page number,
page 40, lordship.
page 40.
It's a land document of 1/11/1956.
Dolil Dan. Abu, what? Abu Mofir. Sheikh, no, not Sheikh. Abu Zakir Mondolo. Pita Mito Mofizuddin.
Seventh line from top, lordship.
Hmm?
Seventh line from top.
So why are you referring to this land of?
Father's name is there. Baidyanath Pal, his land. Seventh line.
Okay, he's the purchaser.
Yes, lordship.
Seventh line. 1, 2,
Bo-
3, 4, 5, 6.
Baidyanath Pal. It's in Nodia. Original is in page
Mm,
26, exhibit
Yes,
5 in the
Baidyanath
record.
Pal. Very well. So Baidyanath Pal is the father
Yes, lordship.
of Samba Pal.
Yes, lordship.
Very well. Baidyanath Pal is of which village?
It's of Nodia, West Bengal, lordship.
Nodia. How will you prove it?
School certificate of her from West Bengal is there.
On Nodia, page number?
Page 47, that was not duly proved, lordship.
You have to prove it.
Yes,
You have to
lordship.
prove this document.
If this document is proved, linkage is proved.
Daughter of Samba Pal, daughter of Bedinath,
Bodhinath,
Bodhinath. And this one is also Baidyanath.
Bodhinath,
No, sale deed is Baidyanath.
Baidyanath.
Bought Oikar,
Oh, yes,
then dot.
Baidyanath,
No, Baidya,
Baidyanath.
not Bodhi.
Baidyanath.
Baidya may become Bodhi also. What else to do? Let her go and examine. There's no other way out. We cannot do anything here.
Yes, lordship. West Bengal.
The petitioner claims that she is the daughter of Baidyanath Pal of village Nodia in the 24 Parganas district of West Bengal, and that Baidyanath Pal is a citizen can be established through the Exhibit 1 sale deed of a plot of land at village Nodia, where the purchaser is Baidyanath Pal, son of late Nisapati. Nisapati Pal.
Yes,
Of what? Dokhinpara.
Dokhinpara, Shang means village, Dokhinpara, Thana, Hasmuti.
Of village Dokhinpara.
Khaskuti. Khaskuti.
Reliance is placed on a transfer certificate which contains of Naihati Saraswati Balika Vidyalaya, which contains the information that Sampa Pal is the daughter of Bodhinath Pal of Vijayanagar. But it's too many things are. One is Vijayanagar and Dokhinpara. Then Baidyanath and Bodhinath. Suppose you prove also
Yes, Lord.
that Sampa is the daughter of Bodhinath of Vijayanagar. You also have to establish that Bodhinath and Baidyanath are same. And resident of Dokhinpara and Vijayanagar. How do you do it?
We can call for the witnesses from
Uh-huh.
those villages because her ancestral home is there. She got married and she came
Understand,
to.
but how do you
as a-
prove it?
Through witnesses from those respective places, Lordship.
কি করবো? It is stated that the petitioner Sampa Pal in the meantime was married and is presently living in Assam. The Ghosh and counsel petitioner states that to establish that Sampa Pal is the daughter of Baidyanath Pal of Dokhinpara of the sale deed, comma, certain witnesses being the neighbors are sought to be examined. The prospective witnesses may file their respective affidavits to be brought on record. If it is good evidence, we'll send it back.
Yes, Lordship.
2 weeks.
Item 32. Item 33.
33 is also your matter, right? Zarina Khatun.
Yes, Lordship. Father is, father's name appeared in page 109, Lordship, 66 voters list.
Father's name
Appeared
in
page 166 voters list, 109, Lordship. Israel Haji. And Nobijan Nessa is mother, Lordship. Page 109.
Isur.
Israel.
Hmm?
Israel law. Israel
Hosur.
Haji. The first one, Lordship.
Hosur, what?
Israel Haji.
Oh, what? Hosurail.
Israel Haji.
Hosurail Haji. Who is he? Father.
Father.
Gaon.
Now is
Gandhari. Gandhari Para.
Para. Then 70 voters list, father and mother. Same village, page 111,
Page number,
111 lordship.
Israel Hazi,
Israel Hazi,
and mother is Nobijan,
Nobijan Nessa.
Gandharipara. Now, some land document,
Yes, lordship.
page number,
Page 121. Her name is in page 122,
1, 2,
122 lordship, serial 14.
serial 14.
Yes, lordship.
Zarina is the petitioner,
Yes, lordship.
Israel.
And brother also adduced evidence. as-
Mr. Sharma. Let it go back. There'll be very few persons having the name Israel. So it's not a very common name. Let them examine and prove it.
And 70 voters list, brother is there and brother adduced evidence as DW2.
Page number,
Page, lordship, evidence is page 60.
page 60.
Yes, lordship. Abdul Goni, Abdul Goni, his name also
Abdul
appears.
Ghani, and where is 70?
70 voters list is page 111 lordship.
Abdul Ghani is there.
Yes, lordship.
Third MSD question. The petitioner Zarina Khatun had been referred to the Foreigners Tribunal number
3 Borpeta.
3 Borpeta for
Case
rendering
39.
an opinion as to whether he's a foreigner under the Foreigners Act 1946, resulting in registration of case number
Case number lordship, FT third 41 within brackets Roman 3 oblique 17.
page number. Say the
Page number 39 lordship.
Page 39.
Yes, lordship.
39%. So tribunal by the opinion dated, it was declared the petitioner to be a foreigner, being aggrieved this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Gandharipara, police station Borpeta in the present Borpeta district, which contains the name of Israel Hazi, son of Jamil. Jamil,
Yes.
not
Yes.
Jamil.
Jamil
Jamil Muddin. It cannot be Jamil Muddin. Son of Jaliluddin.
Jaliluddin.
Son of Jaliluddin. At serial 341, and it is, and that of Nabir Nessa, wife of Israel, at serial 342. And it is claimed that Israel Hazi is the father and Nabijan Nessa is the mother of the petitioner. Further reliance is placed on the voters list of 1970 of village Gandharipara, containing the name of Israel Hazi, son of Jalil Muddin, at 334, Nabijan Nessa, wife of Israel, at 335, and Abdul Ghani, son of Israel, at 337. Abdul Ghani had rendered evidence before the tribunal as DW2, wherein he states that Zarina Khatun is his sister. A land document pertaining a plot of land at village Gandharipara is also relied upon, which contains the information that the name of Zarina Khatun had been mutated in place of Israel Sheikh, in place of a land at village Gandharipara, as per the order in mutation case number BAR SARR stroke 2019-20 stroke 853 stroke FMUT. The date of the order is not there. Na? No, by the order dated 4/2/2020. In view of the above, remanded back to examine the voters 66 and 70 of village Gandharipara as well as the evidence of DW2 and also the Jamavandi of the plot of land at village Gandharipara and pass a reasoned order. The tribunal to examine the Home Department or if advised may be allowed to cross-examine DW2. Nobody may also make a verification and file report before the tribunal upon doing the needful reasoned order.
Item 37 for orders.
Some correction.
Some correction. What kind of correction?
Page 11 of IM
Page 11,
11. Paragraph 5.
paragraph
5.
5. Page 11.
Pramotho Das is the son of Prahlad Das.
Sorry,
Paragraph 5,
paragraph 5, page 11, yes.
line number 4. Pramotho Das
Pramotha Das,
is the son of Prahlad Das.
son of
Prahlad Das.
Prahlad Das. No, what correction you want?
Son of actually Pramotho Das and Babul Das are sons of Prabhat Das has been written. And another grandson,
No. Which the correct line will be in what manner?
Pramotho Das is the son of Prahlad Das.
Pertaining to Pramotha Das, semicolon Babul Das and Bidhan Das,
Then
where it is
next,
stated that Pramotha Das and Babul Das are sons of
Prabhat Das.
Prabhat.
But it is Babul Das is correct. Pramotho Das is the son of Prahlad Das.
Babul Das is the son of Prabhat Das.
Prahlad Das. Prahlad is the
Babul Das is the son of Prahlad Das.
Yes.
And Pramotha Das is the son of
Babul Das. Babul Das is the son of Prabhat Das. It is correct.
No, I have not understood what you are saying.
Pramotho Das and Babul Das both are shown to be Prabhat Das' son.
No, forget about this shown to be. What should be the correct one?
Pramotho Das is the son of Prahlad Das.
Pramotha Das, son of Prahlad.
And next, Bidhan Das is the grandson of Prabhat Das.
Prahlad Das and Bidhan Das is the grandson of, that is, we written it correctly, grandson of Prahlad Das.
Not Prahlad, it is Prabhat Das.
Prabhat. Okay, this one should be Prabhat.
Yes.
Prabhat spelling right, P-R-A-V-A-T or P-R-A-B-H-A-T.
Prabhat.
That is more correct.
Yeah.
And who is Babul Das now?
Babul Das is the son of Prabhat Das. It is correct.
Babul Das is the son of Prabhat Das, Pramotha Das, son of Prahlad Das, and Bidhan Das, son of grandson of Prahlad Das. Prabhat Das.
Prabhat.
The paragraph 5, for incorporating certain correction in paragraph 5 of the order dated 21/5/2023 in WPC 7024/2019. In paragraph 5, it be read that Pramotha Das is the son of Prahlad Das and Bidhan Das is the grandson of Prabhat Das. Whereas Babul Das is the son of Prabhat Das. This much? With the aforesaid correct, the paragraph 5 of the order dispenser be read accordingly as per the correction indicated above.
In cross title, it is correct. It was correct.
The other provisions of the order remains as provided. I allow to the aforesaid correction.
Not.
Hmm. এটা লই লওঁ নেকি আৰু চাৰিটা কপদৰ লিষ্ট বাকী আছে কপদৰ লিষ্ট অংকিত মই এইটো আঁকি দিছিলোঁ কেতিয়াহে চাওঁ Records,
Record, one file has already come.
one has come.
Other one, yes. Because
No,
2002
what we actually, we wanted the records for a very limited
Limited.
purpose. There is two OMs, one of 14 and one of 16.
Yes. Or
They
2002.
they contain certain provisions. Those provisions are sought to be now interpreted. One side tries to interpret it in one manner, another side in another manner, and the government in almost a third manner
Yes.
by virtue of the affidavit. So to get the correct interpretation, the note sheet, if it contains why you had issued, you're required to issue this notification and for what purpose, that may throw some light in how to interpret it, number one. Number two, you had taken a specific stand in your affidavit. That's clause 4, thus it is seen that, as if it is seen from that clause 4 itself.
Right.
Then in respect of the other one, you had taken a definite stand that consequential seniority
Right.
is had been withdrawn. If the affidavit actually depicts what had transpired before at the prior to the issuing of the two notifications, if it actually depicts what had transpired, then it can be done by means of an affidavit. Okay. But if the affidavit intends to further something
That is not,
which is not there,
that is not permitted.
I think that para 21 Mohinder Singh Gill, you cannot
Not
do it.
permitted.
You cannot reframe your case now and put it in a better way that, oh yes, that had happened at that time.
True. For that purpose is.
So these two purposes,
Right now, I am mentioning for different, I am not feeling well today. I want to go right now for my, I'll make my submissions tomorrow. So as files are concerned, one is come, the other one
okay,
is.
if
yet
you're
to
not
come.
feeling well, definitely
Right.
we take note of that. You want it tomorrow?
Tomorrow.
Yes, tomorrow we'll hear you. Today we can start with Mr. M.K. Chaudhary for the other petition.
Yes.
Because what we feel, although it's a common judgment in two writ petitions, the issues may be entirely different. As if we are hearing two different writ petitions separately.
Yes, fine.
So for that purpose, we hear you entirely on your case as,
In fact, my
although,
I have
not- sorry,
I have not replied to the submission of Kane.
you have come a little this side.
I have not replied to the, because as a respondent,
No, you reply.
yes, I'll reply then.
Only
Again, I'll have. to
our
reply for-
only endeavor is kindly make it as short as
Short
it
as
is possible.
Yes,
We
yes.
don't say if it is not possible,
No, it
still
will
you
be
are compelled to make
I-
it
will
short.
be- I'll be very brief.
So that we can deliver a judgment.
Yes. I'll be.
We
very
have no
brief.
difficulty in hearing you.
Yeah.
If you go on hearing you, the
no.
judgment will go after the
I'll be very
vacation.
brief.
Definitely.
My lord,
I'll try to assist.
And
your
if it
lordship.
is,
my lord, what I understand from my learned's friend's point of submission that he wants to give the reply to Kane.
no, we will examine Mr. Chaudhary, whether they were respondents in your writ petition or not.
In my repetition.
Merely because two writ petitions had been dealt with a common judgment. If a party is involved in one of the writ petitions,
They are, my lord, they have implicated their party.
in the other writ petition, they are not involved in any manner. In the appeal against a common judgment, for that writ petition, the others are not required to be heard.
Yes, but then. my
Because
lord,
it is your independent writ petition, only it happened that
yes, my lord,
it's
what
a
I-
part of a
what I-
common
my lord,
judgment.
What I was submitting was to my lord, save the time of the court. If he will reprise to Kane Chaudhary, and before that, my lord, if I argue my case, in the event your lordship allows my writ petition, the other petition may not be decided at all, my lord, it may not be required to be decided. And in the event your lordship,
So do you
rejects
suggest
my
that I
petition-
hear your petition first?
yes, my lord, that is my submission, my lord.
If you, because I believe in one writ petition that clause 4, I believe.
Actually, what has happened in Bhagwan Patter's case, 505,
That is the main case where I appeared and my
Ah.
learned friend. Mr.
I think you
K-
were for the petitioner in that
Yes,
case.
my lord,
Ah.
because I challenge the constitutional validity of clause 4.
Clause 4.
Saying that it is in violation of R.K. Sabharwal.
Huh.
To that, the judgment was delivered and my learned senior colleague had
Challenged, I think, the
the-
OM as
the
a whole.
Entire OM, and that was an ancillary part. The main part was my case. And in
No.
fact, your lordship
Individual
yesterday,
writ petitions, everybody is individual.
No.
No one is
Actually, what had
ancillary
happened,
or subsidiary. to
the
anybody
learned single
else.
judge wanted, since he connected matter, because what had happened, after clause 4 was brought in, all reserve candidates lost their seniority. And there was a lot of challenges made.
So your
The-
challenge to clause 4 is good. For your
Yes,
purpose
yes.
is,
So that's the reason. I
as your
want to
clients
reply.
have suffered something, you want to challenge it.
Yes,
We'll hear you on that. We'll
Yes.
hear on the acceptability of clause 4.
yes. Because,
Mr. Chaudhary submits that he tries to give it a particular meaning.
yes.
Mr. Ken Chaudhary.
Yes.
Mr. Mojumdar is also seeking to give it a particular meaning.
But the entire judgment.
You
was
also
based
give
on-
your own meaning.
But the entire judgment was based on my Bhagwan Patar,
Maybe.
which struck down clause 4 as violative of R.K. Sabharwal.
Maybe.
That's the.
So, but Mr.
But-
Chaudhary also will have to hear him.
Yes,
After all,
yes,
he is
well,
before the
because
court
they
with
are
some
also
cause.
answered very
Then, my lord, in the event your lordship holds that, my lord, the entire OM
Uh-huh.
should go, then my lord, the clause 4.
It's
will also
another
go.
reason whether we accept Mr. Chaudhary's case
Yes,
or we
yes,
reject it, but we have to hear him.
Yes.
So if your lordship hears me first, perhaps, my lord, before he replies
So-
to Ken Chaudhary.
So
that
you want
message
to
will-
start?
be-
Yes, we'll do it that way, no difficulty.
Well, not only tomorrow, if it can be day after tomorrow.
Sorry.
If the Mr. Mojumdar's part, if it can be day after tomorrow, I have some problem.
You also want to give a reply tomorrow?
No, the case which will be continuing tomorrow, since Mr. Mojumdar is leaving, Your Lordship, he has fixed it tomorrow. Can it be day after tomorrow? For, I have some little difficulty tomorrow.
See, we have no difficulty.
I can
Difficulty
only
is,
make a request.
no. We have no difficulty at all in accepting any kind of request. Subject to whether he'll get a judgment before vacation or he'll not get
Yes.
it. That is for the parties to
In
be.
fact,
My lord, I
Because
request,
we
my lord,
also need a reasonable amount of time
yes, Your
to
Lordship.
write, correct,
Yes.
and sign an order.
In fact, the reply which I was supposed to give for against.
And you don't expect that we'll be working overtime and leave aside all other work and ensure that a judgment will be. Judgment will be delivered on a regular course.
Madam.
To be taken note of that there are some 60, 70 odd matters. We have to give equal importance to all the matters and accordingly proceed.
Absolutely. And in
So
fact, the reply will
therefore-
be very brief also.
My lord,
So therefore,
if he is, my lord,
Very
if he is not available tomorrow, my lord, then let him complete his
Leave
argument
your-
so that, my lord, the continuity of the hearing is not, my lord.
Because I'll be very brief.
See, our endeavor of continuous hearing is to
Complete it. within
make
a-
it an effort whether we can
Yes,
deliver
sir.
the
Well, we are
judgment
fully
before the
agreement with
vacation
your
is
lordship.
there,
We are
because
fully-
Let him
many
complete.
people are affected by
Yes, yes,
all
yes.
these
Very fine.
proceedings.
Well, we are fully in agreement with your lordship and I'll try to be very brief.
My lord, then let him argue.
And the continuation.
And
will
what
continue day
happens
after
is after hearing a matter for some time, certain submission statements at times become repetitive.
Yes,
We are already aware of it.
yes.
Only thing is,
We point out the main.
only
which
thing
was
is
left out.
how you see clause 4,
Yes,
how Mr. Ken Chaudhary sees clause 4, and how Mr. Mojumdar sees this clause 4. And depending on the interpretations, we accept either of the three.
Yeah.
Or option is also to go for a fourth one. We may not accept either of the three and go for a fourth one also, if we see it appropriate with reasons. So
tomorrow. man.
So-
Well,
So
let it
let
be
him
day
argue
after
tomorrow, my lord, so they.
let Mr. Mojumdar go. He's not
Yes,
feeling well.
yes,
Yes, yes. Day after tomorrow.
You don't have to overstrain.
Man,
yourself.
please.
No, if you continue today, then your absence tomorrow will not, discontinue the
Up to
hearing.
you.
So let him.
We have some 5 or 6 matters. Let us finish it and
Oh, yes.
take over this.
Yes.
Mr. KD Chaudhary, that matter, what to do?
Lordship, I stick by whatever I.
Sorry.
I'll stick by whatever I have said, Lordship, so far as the rights are concerned. So far as the property rights, Lordship, I have.
Should he understand that the proceedings are closed
So far
or
as Lordship, I am concerned, Lordship, I do not have anything to add.
closed? Tentatively, let us keep for 30.
Yes, yes, yes.
If you feel something in the meantime, and also understand that.
Yes.
Item 38 for hearing.
Yes, Madam Ghosh.
Have his lordship.
Mhm.
Lordship, petitioner name is Marjina Khatun, lordship. Pehले voter list.
You can
of
straight away come to who is the father.
Ni-
Because these
1966
preliminary sentences, this is against that order, this name is so and so. Come straight to the
1966 voter list, lordship, page 15,
page 15.
1515.
Fine.
Grandfather name is appeared. HCL number 32, Hussain Ali.
Sorry, just a minute. Hussein Ali, he is the father,
Grandfather, lordship.
grandfather. Okay.
Aisha Khatun is a grandmother.
Aisha. Aisha Khatun,
Is a grandmother.
grandmother.
Lordship,
Very well.
page
And this is of which year?
1966.
Where is it written? 66. Of which village?
Abrar Vita.
Abrar Bhita, very well. Hana Lakhipur.
Page 21, lordship, on sale deed. His
Mhm.
father and deed.
Page 21 is a sale deed. Sale deed by whom?
Sale deed. The purchaser name is Muhammad Bahadur Ali Sheikh.
Muhammad
Is
Bahadur
the father,
Ali
lordship.
and Abrar Bhita. So you claim that this Hussein Sheikh is Hussein Ali of the 66 voters list. Very well. Is there any difference between Hussein Sheikh and Hussein Ali, or there is no difference? Mhm. So this is sale deed of 76, Bahadur. So Bahadur is the father.
Yes, sir. Lordship, page 28, lordship, 19.
No, Bahadur Ali is the father.
Yes, lordship, father.
Okay.
Page lordship 28, lordship, voter list of 19. Page 26, voter list of 1979, lordship.
79, Abrar Bahadur, son of Hussein. Abrar Bhita.
The village is same, lordship.
What happened to Hussein? Hmm?
Hussein is the grandfather, lordship.
Ikon. Ano Kangal, Ong Kangal. That sale deed is between father and son.
Yes, lordship.
Huh?
Yes.
Well, so now Bahadur, son of Hussein. What happened to Hussein?
Hussein, lordship.
Hussein existed till 1970, I think.
1970.
So what happened to him in 1977?
He died, lordship.
Hussein died. Aisha also died.
Yes, lordship.
Kadbanu. Kadbanu must be another wife of Hussein. She
Yes,
also died.
lordship.
She also
Kadbanu.
died. How can there be so many deaths within 7 years? That all the earlier names are obliterated and suddenly one new name comes in claiming to be the son.
That's a complete voter list, lordship.
Produce the complete. Petition us to produce the complete voters list of village Abrar Bhita of the year 1966, 1970 and 1977. So as to enable the court to examine as to what happened to Hussein Ali, Aisha Khatun, Kadbanu Nesa. All they are wives of Hussein Ali.
Lordship, Aisha Khatun, Kadbanu.
Aisha Khatun, Kadbanu Nesa, Natujan Bibi are the 3 wives.
Yes.
So if there are 3 wives, at least one of them must have been surviving for his name to appear with Bahadur. So is to enable as to what happened to Senari. Aisha Khatun Karban Natujan Bibi in the year 1977. Inasmuch as the voters list of 1977 produced contains only the name of Bahadur Ali, son of Hussein, and Sarbanu, wife of Bahadur, and the names of the others are absent. Response.
79.
Item 39.
79.
39,
79. Voter list.
not 77. It is 79.
Lordship, my father is
Hmm.
Posimuddin, my lord.
Page number.
Voter system 1965, that is 42, page 42.
Qasimuddin. He is a father or grandfather?
Father.
Father.
Posimuddin and Aimol
Aimol
Bibi.
Bibi is the mother.
Aimon is my mother, but here Yan is written, but Yan should be.
Sorry.
Aimon.
Okay, Aimon, it's okay, fine. So now
And another
65, Qasimuddin is the father.
father.
Now, which document will show that Sahara is the daughter of Qasimuddin?
Village headman certificate, village headman was examined, and Panchayat secretary was examined.
Did these two witnesses have any special means of knowledge about the existence of this relation?
Given in
Sorry,
cross also in sheep as well as
No,
in
no.
cross.
did they have any special means of knowledge about the existence of this relation that Sahara is the daughter of Qasimuddin? Please go to section 50 of the Evidence Act.
Beside this, elder brother was also examined. Elder brother.
How do you know that he is the elder brother?
He stated everything. And
How do you know that that man is the elder brother?
he stated
See, you often in a
his documents also
light-hearted manner we
in his
say
SLC pass certificate also.
school children, when they're required to call their guardian, they just get hold of anybody from the street and present it to be somebody. How do you know that the same principle is not adopted in these cases? Merely calling a man his brother is not a brother unless you establish through material that he is the brother. Which material will show that he is the brother?
He stated Qasimuddin, voter list of 65, as well as the mutation of land document.
Where is the mutation?
47. From 47, page number. Vernacular is.
Where is the vernacular?
Vernacular is, my lord, 50. My lord, 50. Original Pattadar, number 2. Qasimuddin, father of Soyod Ali. And number 13 is Sikandar Ali, brother of the proceeding. 13 is Sikandar Ali. 13 is Sikandar Ali.
13.
Who deposed that Sahara was her sister, his sister.
This is of which village?
Kasimpur.
Okay. Yes, Mr. Sharma, what do you say? Where is the evidence? Sikandar Ali.
Page 21.
21.
21.
Yes, Mr. Sharma, we send it back, you cross-examine this. Third, Mr.
My lord,
Your name?
S.C. Pandit.
SC Pandit, Land Council for. What is your name? What's the her name? The petitioner Sahara Khatun had been referred to the Foreigners Tribunal number 1, Nalbari, for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of FT Null case number N230/2016. Tribunal rendered an opinion dated 2011-2017 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ petition, reliance is placed on the voters list of 1965 of village Kasimpur, police station Nalbari, Moja Notun Dehor, in the present Nalbari district, which contains the name of Kasimuddin Sheikh, son of Syed Ali at serial 249, and that of Aimal Bibi, wife of Kasimuddin at serial 250, and both are shown to be residing in the same house number 38. Further reference is
my lord, 53.
Mr. Pandit. Let us do our own work. You have done your work. Further reference is made to the Jamabandi of a plot of land at village Kasimpur, which shows that, which contains the information that as per the order of the circle officer dated 25/1999, the name of Sikandar Ali was mutated in place of Kasimuddin, and accordingly at serial 13 of the Jamabandi, the name of Muhammad Sikandar Ali, son of Kasimuddin, had been entered, and the name of Muhammad Kasimuddin, son of late Syed Ali, had been deleted. Accordingly, the petitioner seeks to establish that Sikandar Ali is the son of Kasimuddin. Sikandar Ali rendered evidence as DW2, stating that the petitioner Sahara Khatun is his sister. In view of the above, remanded back to the tribunal to examine the voters list of 1965 of village Kasimpur, the Jamabandi of the plot of land at village Kasimpur, as well as the evidence of DW2. Full stop. The petitioner to produce the complete order of the circle officer dated so and so for examination with tribunal. The respondents in the Home Department may cross-examine DW2 as may be advised. The respondent Home Department may also make a verification and submit a report before the tribunal. Upon doing the needful, a reason order be passed.
Item 40.
It be your lordship, call for the attendance register of the,
Sorry,
your lordship call.
to
for the
produce the
attendance-
original school register. Is it there, Madam?
Lordship, I had received the register and I found some discrepancies in between the certificate and register, admission register.
Let's see. Where is the certificate, page number?
18, my lord.
18.
18. Annex of. That's the type copy, translate copy.
18.
Original was 19.
নম্বর পলাশগুড়ি প্রাথমিক বিদ্যালয়, জয়যুক্ত বর্মন, পিতা মুখময় বর্মন, সুখময় আৰু কি বৰি গাঁও কুমাৰবৰী, I think. Which serial number?
Lordship, last one. of the admission register.
Last entry is always most difficult entry.
Lordship.
What do you do? Raise a police case?
Lordship.
My lord, my senior will, can I?
Sorry.
Can it be day after tomorrow, my lord? My senior will submit my lord regarding this matter.
No, we have nothing to do with you. We are registering a police case against the school authorities, not against a petitioner. So why should we hear you on that? School authorities had issued a certificate which you are relying on. We have called for the original records to verify the authenticity of the school certificate. The record appears to be fabricated. So why should we hear you on that? Petitioner has no right to hearing on it. No, 71 is right because of date of birth is 1962. Why is it? Definitely, Trees Bosarat, somebody has not taken admission in a school. Apart from, it appears that the later entries in the register are subsequently added. Did this person enter the LP school at the age of 30? Can it be conceived that at the age of 30, somebody will be admitted in a LP school for the first time? No. The date of birth recorded is some 1962. And this name is entered in the admission register of the year 1992. How can it be? Some manipulation has to be there by somebody. Pursuant to our order dated 35/2023, the school admission register in original of 567 number 1 Paharguri Primary School of Killing Valley, Morigaon is produced before the court. The production of the record was called for to verify the authenticity of the information contained in the transfer certificate issued by the headmaster of the said school, which contains the information that Joyjukta Bormon is the daughter of Sukhomoy Bormon of village Kumarbori. The certificate reflects that the Joyjukta Bormon completed her studies in the school in the year 1971. And her date of birth is stated as 6/2/1962. The admission registered in original, which is produced before the court, shows that the name of Joyjukta Bormon had been entered in the school admission register in respect of a page pertaining to the year 1992/93. And the date of birth is also shown to be 6/2/1962. If the name had been entered in the school admission register of 1992, when the person was born in the year 1962, it has to be understood that after the age of 30, Joyjukta Bormon had taken admission in the school concept. But at the same time, the certificate depicts that she had completed her studies in the school in the year 1971. Further, it is noted from the admission register in original that the handwriting and the manner of writing the entries last 5 entries in the school admission register appears to be different from the other entries in the same given page. What is noticeable is that in respect of the other students in the admission register, their respective dates of births are somewhere around 1986, 88, etc. But in case of Joyjukta Bormon, the date of birth is 6/2/1962. A reading of the school admission register discloses a prima facie manipulation by some authority somewhere. The superintendent of border, who will register the case?
Lordship,
Who will register the police case?
the OC with DO. DO can.
No, who will register the case? Who will be informant before the police?
DO, Lordship.
The district elementary education officer Nalbari to register
Morigaon, Lordship.
Morigaon to register a case before the officer in charge of which police station?
Jagirot.
Of the
Jagirot.
Zazori.
Jagirot.
Jagirud, Lordship.
Before the Jagirot police station or any other appropriate police station under whose jurisdiction the 567 number 1 Palahguri Prathamik Vidyalaya is located. The police, upon registering the case and conducting the investigation, shall submit a preliminary report before the court on the authenticity of the admission register. The admission register in original is returned back to MS ESCON, Land Council for the Education Department for transmission of it to the District Elementary Education Officer, who shall place the same before the police to seize for appropriate action. Joyjukta Bormon is a man or a woman? Man. It's she likhibo, he likhibo.
Item 41.
A copy of this order be made available to MS ESCON, Land Council for the Education Department. Mr. Hawk.
Page 28, 1966 voter. My father,
Petitioner may produce the school certificate corresponding to the admit card.
I have filed my additional affidavit also.
Which page?
Page 64.
64. The school certificate corresponding to the admit card. Then I found admit card and next say. Where is the school certificate corresponding to the admit card?
My page 64.
64? 64, yes. Hussein Ali.
My.
No, of village Kayastha Gaon. Mr. Hawk, to be frank enough, today I think was the 9th school admission register we examined. Out of them, only one was a clear one. 8 were fabricated. What can we do? Let us call for the original school
My lord,
admission register.
I have reduced voter list also, my lord.
No, we'll examine, but as you are relying on school, they say, so let us call for the admission register.
But voter list also are there.
Then are you abandoning this?
No, I am not,
If you want to abandon
No.
this point, we'll accept it.
because your lordship directed me to something.
No, no. We directed because you relied upon.
My
You relied upon an admit
admit
card.
card, there is no village name.
We find that admit card does not contain sufficient
Yes.
information. So every admit card, there will be a corresponding school certificate.
Fine.
We wanted that.
Fine.
That's all. And if you are not relying on the school certificate and admit card, tell us. We'll abandon that. If you want to abandon that point.
It's very difficult, my lord.
Otherwise, we call for the school register. Because now the situation is such,
Yes, that is,
almost at the stage that where we can say we have lost faith in these
Yes.
school certificates, the way things are manipulated.
that is correct.
As required by the earlier order of 2/3/2023, the school certificate issued by the principal Vilasibara Public Higher Secondary School is produced before the court, which contains the information that Hussein Ali is the daughter of Muhammad Nosir Ali Mandal of village Kayastagaon. If you are a man from Borpeta district, why did you, your schooling was in Vilasibara?
He passed matriculation from that school.
Why?
That reason
Borpeta, you have a number of good schools there.
from some center possibly, my lord, in different, some center of my examination possibly in different, maybe.
No,
I don't
no,
know, my lord,
center of
I-
examination is a different aspect. You may be reading in one school, for metric you'll be required to sit in another school. But you are normally a man from Borpeta district
It is from, I put this.
usually does not go to Vilasibara Dhuri district to have his schooling.
My lord, register may be called.
Unless it's some good reputed public school or something that people send it for those boarding school and all. Otherwise, it's always the nearby good school. To verify to examine the authenticity of the contents of school register, the admission register in origin of Vilasipara Public Higher Secondary School. When was he admitted in the school?
That is not, my lord, mentioned. It's not.
Be produced. Which may reflect the admission of Hussein Ali in the said school. Whenever it is there, you produce it.
Fine.
Copy of the order, Escort Education Department.
Okay.
Item 42.
Yes. Ainat Hawk.
Lordship, 66 voters
Page
list,
number.
47 of grandfather and grandmother of village
Page
Kismat.
number,
Moinburi.
page number 47.
Yes, Lordship.
Malizuddin.
Mokri,
So for law. Son of
Jamshed,
Jamshed. He is the father,
no, grandfather.
grandfather. Right. Village is Kismat,
Kismat Monburi.
Kismat Monowari. So now who is the father?
Father, then page 49, Lordship, here. And in 66, grandmother also was there, Lordship.
Sorry.
So Bura, in 66, page 47, along with
No,
grandfather.
you
grand-
referred to page 47.
47,
We have
yes.
taken note of that. Then after that,
then 49 lordship.
49 years.
Mofis
This is the
Ali,
village,
different village.
Salkwa.
Salkwa. But grandfather, grandmother.
so
then
how you
father,
happen to reach from Kismat Monowari to Salkwa?
Because river erosion was there.
Any material to prove that?
No material means I don't have voters list. It's not there.
Voters list is whosoever goes to
Yes.
whichever place, manage the official, you get a
yes,
voters list.
except
It's
that
not
I
a
don't-
difficult proposition.
From 18
Petitioner may produce any relevant material which may show that the family of Malizuddin
Yes.
or Mofizuddin, son of Jamshed of the 1966 voters list of village Kismat, what,
Moyanburi.
Moyanbori, had later on shifted to village Saulkhwa, so that the name of Mofizuddin appears at serial number
Mofis at serial number 42 lordship.
42. At serial number 42 of the said list. List of.
Item 43.
Yeah, please.
Where is the father? Page number
66 voter list lordship will find at page 27.
27.
Grandfather Kajol Sheikh.
Kajol Sheikh, grandfather.
Father Jalaluddin, that's serial number
Father
11.
Jalaluddin, same list.
And Ghuramara part.
Ghoramara. Which document will
My
show that Sakitan is the daughter of Jalaluddin?
School certificate ever good in. My lord, brother was examined.
How do you know he is the brother?
Father is voter with mother.
Any name of the brother and Jalaluddin
My
together?
lord, no,
Sorry?
mother is with the brother. Mother, my lord, lordship will find in 85 voter list.
No. In 65, who is the mother? Khaiful.
No, my lord. Mother is Khaiful is the stepmother.
Stepmother.
Own
So now
mother
where
is
is the
coming
mother?
in voter list of 1985. Lordship will find at page 50.
85. Till 70, mother did not marry.
Yes, madam. Stepmother is in the 60 page voter list. 85 voter list, mother is with father.
Page number
Page 50, my lord.
50.
My lord, 50. Jalaluddin Guljan Bibi is the own mother.
Jalaluddin. Jalaluddin is the son of Kajal Sheikh.
Kajal. Here is also my lord.
And here Jalaluddin is the son of
Kajal.
Kajal. Jalaluddin father, Kajal. And who is the mother?
Guljan Bibi is the mother.
Guljan is the mother.
Now Lord.
Guljan is age 35.
My lord. Yes, my lord. Age difference.
Village is also different lots.
Village Ghoramar. Village is Ghoramar. No, village is different.
Yes.
Dholagaon.
My lord.
Village is Dholagaon.
My lord, the village Dolagasa is out
No,
of my lord Ghuramara.
1966 is village Ghoramara part 1
Yes, my lord.
and 1985 is village Dholagaon.
Dolagao.
Dholagasa.
Dolagasa.
Hmm.
My lord, we have
Adjacent village.
instructed that the Dolagasa is the new village created out of the Ghuramara. The police
Achha,
station
Dholagasa is a village created out of the
of-
original Ghoramara.
Ghuramara.
Very well.
Lordship will find in the 97 voter list that polling station in Dolagasa is same Ghuramara.
No, even polling station is Ghoramara in page 50 also.
My lord. Yes, my lord.
Page 50
So-
polling station is Ghoramara. Yes, Mr. Now, who had rendered evidence?
My lord, Nisar Ali, brother, lordship will find at page 62,
60,
97 voter list. Guljan and Nisar is in the same.
62, Guljan and
Nisar Ali, brother.
Nisar Ali, brother, and Guljan is the mother. Where is the evidence of Nisar?
My lord, at page 66.
66. Yes, Mr. Sharma.
Nisha
back.
Ali.
Put here. Heard Mr. A.R. Chigdar, Land Counsel for the petitioner, also heard Mr. G. Sharma, Land Counsel for the department. The petitioner Sukitan Nisa had been referred to the Foreigners Tribunal number 2, Bongaigaon at Abhayapuri, for rendering an opinion as to whether she is a foreigner under the Foreigners Act, resulting in registration of BNGN-FT case number 437, page 63. Tribunal rendered an opinion dated 30/10/2018, declaring the petitioner to be a foreigner, being aggrieved this writ petition is instituted. In the writ petition, the petitioner relies upon the voters list of 1966 of village Ghoramara, Part 1, police station Uttar Salmara, in the present Bongaigaon district, which contains the name of Kajal Sheikh, son of Ash Sheikh, at serial 8, and that of Jalaluddin, son of Kajal Sheikh, at serial 11, where both are residing in the same house number 3. It is claimed that Kajal Sheikh is the grandfather and Jalaluddin is the father of the petitioner. Similar information is also available in the voters list of 1970 of village Ghoramara, Part 1. Petitioner thereupon relies on the voters list of 1985 of village Dholagasa, which contains the name of Jalaluddin, son of Kajal, at serial 447, and that of Guljan Bibi, wife of Jalal, at serial 448, where both are residing in the same house number 17. It is claimed that Jalaluddin is the father and Guljan Bibi is the mother of the petitioner. As the voters list is of the year 1985, use of village Dholagasa, Mr. A.R. Chigdar, Land Counsel for the petitioner, states that Dholagasa is a village which had been carved out from the erstwhile Ghoramara village. And although the name appears to be different in the voters list of 1985, in fact, it is the same village. The state's submission may have some relevance in as much as in the voters list of 1985, it is noticed that although the name of the village is Dholagasa, but the polling station is Ghoramara LP School. Further reliance is placed on the voters list of, where is the other one?
97, my lord, page 62.
62. Further reliance is placed on voters list of 1997 of Dholagasa, which contains the name of Guljan Nisa, wife of Jalaluddin, at serial 974, and that of Nisar Ali, son of Jalaluddin, at 975, where both are residing in the same house number 19. As the name of, it is claimed that Nisar Ali is the brother of the petitioner. As the name of Nisar Ali appears along with Guljan Nisa, where the name of Guljan Bibi appears along with Jalaluddin, Guljan Nisa in the voters list of 1997, and the name of the names of Guljan Bibi and Jalaluddin appear together in the voters list of 1985, both of Dholagasa, where the name of Jalaluddin appears along with Kajal Sheikh in the voters list of 1966 and 70, although of village Ghoramara Part 1. It is claimed that it is claimed that the petitioner had established that Nisar Ali is the brother of the petitioner. Nisar Ali is also a son of Jalaluddin. Full stop. To substantiate prove that the petitioner Sukitan Nesai is the daughter of Jalaluddin, Nisar Ali had rendered evidence as DW2 before the tribunal, stating that Sukitan Nesai is his sister and as well as daughter of Jalaluddin. In view of the remanded back to examine the voters list of Gotegihan, as well as the evidence of DW2 and pass a reasoned order, the respondents in the Home Department may make their own verification and submit a report before the tribunal. And the respondents may also cross-examine DW2 as may be advised upon doing the needful. The reason already passed.
Deep lovely.
44. Yes, Mr. Ahmed.
Little lordship, the base
Mhm.
lordship, 28 lordship,
Sorry,
28,
28.
66 voter list.
এটা থেকে আর প্রথম তিনটা নেব আরো সেই তিনটা পেজ নাম্বার
28 lordship. 66 voter list lordship. The place Kandavara lordship, the next page is Zumar Ali's grandfather. Zumar Ali grandfather lordship, Suratan
He is the grandfather
grandfather.
and
Grandmother Suratan.
Suratan grandmother. Now who is the father?
Page lordship, next page lordship, 70 voter list.
Page number
30 lordship.
30.
Kandavara lordship, then
Hmm.
next page is Zumar Ali,
This is of which village?
Kandavara. Assembly,
Same Kandapara. Jumar Ali is the
grandfather,
Omar Ali is the father.
father lordship. TW2 is the Umar Ali.
This is of which year? 70.
70 lordship.
And now which document will show Omar is the father?
The lordship, Umar Ali is the DW2 lordship.
Sorry.
DW2,
Acha, Omar Ali,
they was before the tribunal.
who is the petitioner? What did you? Heard Mr. N. Ahmed Land Council for a petitioner, also heard Mr. G. Sharma. The petitioner Rahima, what is her name? Ramina Khatun had been referred to the Foreigners Tribunal number one, Borpeta, for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number 101. So 17. Tribunal rendered an opinion dated 4/2/2019 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Kandapara, which contains the name of Jumar Ali, son of Joharuddin, at serial 20, and that of Suratan Nessa, wife of Jumar, at serial 21. It is claimed that Jumar Ali is the grandfather and Suratan Nessa is the grandmother of the petitioner. Further reference is made to the voters list of 1970 of village Kandapara, contains the name of Jumar Ali, son of Joharuddin, at serial 24, Suratan Nessa, wife of Jumar Ali, at 25, and that of Omar Ali, son of Jumar Ali, at serial 27, where all of them are shown to be residing in the same house number 10. Jumar Ali had rendered evidence before the tribunal as DW2, stating that the petitioner Ramina Khatun is his daughter. In view of the above, remanded back to the tribunal to examine the voters list of 1966 and 1970 of village Kandapara, where the voters in 1970 contains the name of Jumar Ali, Suratan Nessa, and Omar Ali together, as well as the evidence rendered by Omar Ali as DW2. Full stop. The respondents in the Home Department may make their verification and submit a report to the tribunal, and as well as cross-examine DW2 as may be advised upon doing the needful.
Item 45 for motion.
Yes, 45, copy of the affidavit Gambura be made available to the Land Council for the Home Department. Got your affidavit?
No, Lord.
Did you get the affidavit filed by Gambura?
No, Lord, my government advocate will. I did not receive it.
By the order of 14/6/2023, the copy of the affidavit filed by the Gambura Postim Delhi village was required to be made available to the Land Council for the Home Department. It is stated that a said affidavit is yet to be made available. It is directed that the Learned Council, through whom the affidavit of the Gambura had been filed, make available the said, provide a copy of the same to Mr. G. Sharma, Land Council for the Home Department. List again.
In the meantime, that she may be protected.
Sorry, no coercive action against the petitioner till the next returnable date.
17 July. Item 1,
Yes, what is item one?
Your Lordship, in this matter, I am seeking an adjournment. The conducting council is in hospital, I see the Hyderabad,
Sorry?
Your Lordship. The conducting council is admitted in Hyderabad Hospital, Your Lordship.
Sai Baba Hospital,
Hyderabad, Your Lordship.
Hyderabad Hospital,
Lordship.
right? For the petitioner is hospitalized at a hospital at Hyderabad, and therefore an adjournment is sought for. Adjourn, list again.
Item two.
By your name, please. What's your name?
Lordship, S.A. Hussain.
Stated by S.A. Hussain, right also.
Item two.
Yes, item two.
But petitioner father name is P.R. Hussain, my lord. His
Sorry?
father's name appear- His father's name appear in the voter list of 1965, page 20, my lord. My lord, in the page-
Hmm. Yes,
Yes, my lord, page 20, my lord.
Page
His
20.
father name. P. Hussain, my lord.
Pira Hussain.
Yes, my lord.
Pira Hussain, who is he? Father or grandfather?
Father, my lord.
Father. 1965, Gaon Amlokhi.
My lord.
And Fulimon Nessa? Fulimon Nessa is somebody else.
Yes, my lord. It's a uncle.
Hmm. Now, who is the father?
My lord. Pira Hussain is the,
Huh?
Pira Hussain is the father.
Pira Hussain father.
Yes.
Which document will show Pira Hussain father of Akasali?
My lord, it's the 1990 voter list.
Page number
Page number 24, my lord.
24.
But my lord, there is some shifting, my lord.
24. Voters list of
1990, my lord.
1990.
From different
Village is
place,
different.
different place. Lordship may permit to.
Sorry.
Bring some documents, my lord. Of the
What
complete
document?
voter list, my lord.
What document you intend to bring?
My lord, complete voter list of the later part of 1970, my lord.
Sorry.
After 1970, complete voter list of the 1970 and my lord, of in respect of the village, my lord, Amlokhi, my lord.
The petitioner relies upon the voters list of 1965 of village Amlokhi, which contains a name of Pira Hussain, and claims that Pira Hussain is the father. Thereupon, reliance is placed on the voters list of 1990 of village Losonbari, which contains the name of Akas Ali, son of P.R. Hussain. It is claimed that P.R. Hussain of the 1990 voters list of village Losonbari and Pira Hussain of the 1965 voters list of village Amlokhi are one and the same person. Petitioner may produce any relevant material which may establish the said fact. Further, the complete downward and upward voters lists of village Amlokhi and village Losonbari from the years 1965 up to 1990 be produced before the court list on switch.
My lordship, there, may I please, my lord?
Sorry?
My lord, there is one thing, my lord. As
A
per the-
little louder. We can't hear you properly.
My lord, as per the order dated 13/9/2020, my lord, the petitioner number 2 ought to have strike down, my lord.
We'll examine all those things later on.
My lord, but save was not been deleted.
Sorry.
As per order dated 13/9/2020, my lord,
Huh?
of order para 20, my lord. That order para
39,
20, my lord.
2020.
27 July.
What is 39, 2020? Okay, 39, 2020.
Yes,
What
my lord.
happened on
Para
that?
20, my lord.
Para 20. Huh?
As my lord, there is no specific
Sorry.
as my lord.
Raised is
that-
directed to delete the name of it from the cause title.
Yes, my lord.
It has not been done.
So not been done.
Yes,
So why are you worried?
my lord, there is two petitioner, my lord.
Sorry,
In this case, my two petitioner, my lord.
two petitioners.
Yes, my lord. As my lord, there is no specific reference against the petitioner number two, my lord. As such, this honorable court, my lord, already been directed to strike down the name of the petitioner number two, my lord.
So now what will happen with petitioner number two? Are you not decided, was he declared to be a foreigner?
Earlier, he
Was petitioner number two declared to be a foreigner?
yes, my lord, earlier he was.
Then how will you come out of that order if you would get your name deleted from the writ petition?
That order was passed, my lord.
Sorry,
Honorable court directed.
court may have directed, court must have directed because of your submissions. Court, suo moto on its own will never delete some name of a. You must have made some submission, made out some case
Yes, ma'am.
resulting in deletion of the name.
Yes, ma'am.
But if you are a declared foreigner and you get your name deleted from the writ petition,
Yes, ma'am.
then how we are going to come out of that declaration?
As per the para 20, sorry, my lord, para 15 of that order, my lord, already been the impugn order has been set aside in respect of the petitioner number two, my lord. As such, that.
Okay, it has been set aside.
Yes, my lord.
If it is set aside, well and good, you be happy with it.
In respect of petitioner number two, my lord, only. Para 15, my lord.
You were given liberty to initiate fresh inquiry
My
against
lord,
them.
they-
Then do it.
they-
It will, your name, K.M. Hassan.
Yeah, ma'am.
Mr. K.M. Hassan, land council petitioner refers to the earlier order dated 13/9/2022 by which in para 20, the petitioner number two stood deleted from the area of petitioners in the present writ petition. Further reference is also made to para 15 of the said order by which the opinion dated 30/12/2017 against the petition number two, Rabia Khatun, had also been set aside. Where in para 16, liberty had been given to the Superintendent's border to make any fresh reference, if so advised, against the petitioner number two. In such view of the matter, no further notice would be taken in this writ petition from the perspective of the petitioner number two.
Item 3.
None appears for the petitioner when the matter is called. List again. On subsequent non-appearance, appropriate order shall follow.
Item 46 to 63 for hearing.
Now, who will start? You will start.
Yes. May it please your lordship. My lord, on the last occasion, my learned counsel, Mr. K. Chaudhary, made threefold submission. The first submission was that the 2014 OM has basically impliedly repealed the 2002 OM, by which consequential benefit was given pursuant to the 85th Amendment. The second ground of challenge was
That
the
implied repeal was in respect of 2014 or 2016?
He says both. because
Or both?
14 and 16. he
Both.
says, Yes. They say, he says that it is so incongruous that they cannot survive and 2000.
No, that we understand. But how can it be both?
Well, that was his submission yesterday.
See, it cannot be both. Because if 14 had impliedly repealed, 16 will be a non-nest. You cannot impliedly repeal something which had already been impliedly repealed.
Because, my lord, what has happened?
Yes,
the
so who was there
submission-
with Mr. Chaudhary yesterday? Let's clarify that one. Have you understood?
Yes, my lord.
If it was impliedly repealed in 14,
Yes.
16 again cannot impliedly repeal.
Because his.
Because it already stood repealed
That
in
is his
14.
ground in the written submission.
Let us see. Who is there, Mr. Ken Chaudhary?
I mean, he was here, a junior leader.
Anyway, please continue.
Yes. My lord, I'll take your lordship and this
So
third,
implied repeal is also a repeal. Hence, once it is repealed, it does not exist anymore. If 14 makes 2002 not to exist anymore, how can it be again impliedly repealed in 2016? Please come forward. You appear along with Mr. Ken Chaudhary. Was it your submission that 2002 OM had been impliedly repealed by 2014 and 2016?
We had made a
Both.
submission with regard to that, that Palai judgment.
Don't add words. Did 2014 and 16 impliedly repeal 2002? Was it your submission?
Also, we had made a submission regarding implied. repeal.
Say, learn to give a simple answer,
Lordship.
either yes or no.
Lordship, that will have to confirm with the senior.
Get it confirmed and come back.
Lord.
Or Mr. Das, are you aware? Was it your submission that 2014 and 2016 both impliedly repealed 2002?
Lordship. Yes, Lordship, because Lordship, my senior has pointed out that all existing notifications and all.
No.
Has been repealed.
So 2014 and 16 both impliedly repealed 2002.
Yes, Lordship.
You agree with it?
To some extent, Lordship. that is-
No. Do you agree that this was your submission?
Yes, Lord.
Tell us one thing. If we accept your submission, if 14 had impliedly repealed 2002, from 14, 2002 did not exist any further. So how can 16 again repeal it? Mhm.
in fact, this was the question which your lordship please put a question to Mr. Majumdar, because Majumdar's argument was very specific. He says that the 2014 has been quashed in the Equality Forum judgment. My contention was that if 2014 is quashed, the entire edifice of post-based reservation collapses in Allah, which could never happen.
No, logically, don't you think so? Mr. Das, logically, don't you think so? Repeal means what?
Exactly.
Something
Why
is
2016
not in
again?
existence anymore. Ordinary meaning.
Hmm.
So if 2002 did not exist anymore from 2014 because of the implied repeal, how 16 can again
Oh,
repeal it?
again, 16 has come.
You cannot repeal a non-existing. Just take note of it.
Yes, Lordship. I will
Yes,
take-
Mr. Das.
But in fact, Mr. Das is right for the simple reason. Yeah, on the first day, the submission was made that in the 2014 when clause 14, it is, there's a word at that all existing orders on the subject are deemed to have been amended to the extent herein. Mr. Chaudhary's argument was that with the coming of the 2014 OM, the all other earlier 2002 OM has also gone. But my objection was that this is not referred to 2002, it referred to the vacancy-based reservation. Because as soon as the post-based reservation came in pursuant to RJS Agarwal.
Mr. Chaudhary, just one. Mr. Das said that your submission was that 2014 and 16 impliedly repealed 2002.
Yes,
If that is so,
yes.
if 2014 had impliedly
My lord,
repealed,
what was not explicit in my lord 2014 has been made explicit in my lord
No, no.
2016.
if 14 had impliedly repealed 2002,
Yes.
2002 did not exist anymore.
Yes.
So how can it be again repealed by 2016?
No, my lord, there was maybe there, my lord, there are some amendments.
So 2002 partially impliedly repealed.
Partially and wholly, my lord.
Okay.
My lord, there are few aspects. For example, my lord, now 2014 specifically.
No,
speaks
we
of-
are not going to detail, just we wanted to
Yes.
clarification because he said that. So 14 partially repeals, not wholly. Okay.
Yes, my lord. it can
Because
be taken-
otherwise, if repeal means 2002 does not exist anymore, 16 cannot repeal a non-existent one.
Can I paraphrase it, my lord, subject to what your lordship says? My lord, 2014 only says that this roster promotion will not determine the seniority. It stopped there.
Hmm.
But my lord, clause 4 of 3816 says a roster promotee, he cannot be considered for a general category.
So that means
Meaning thereby,
2016 had impliedly repealed.
both. Well, there's nothing that subsequently OMs cannot, take care of a situation which was visualized when earlier.
No. Moment we understand the concept repeal. Repeal means it does, the other one does not exist anymore.
My lord, I would put it this way, my lord.
Uh.
What was implicit in 29/12/14 has been made explicit in 3816. That is how, my lord, I'm saying both.
No.
That is my humble. Well, I
Otherwise,
was on legs in.
otherwise, difficult to conceive.
Yes,
no,
of
because
course, my lord.
something
One
when
thing can be repeated
becomes
twice.
non-existent, how can another document again make it
My
non-existent?
lord, my lord, my humble understanding is this subject was evolving. My lord, therefore, my lord, it all started
So
with
you put it
Nagras.
that 14 had implicitly and 16 had made it
Explicit.
Okay. Accepted.
Deeply.
So- Yes, Mr. Patel.
So his first form of argument was that 14 and 16 has impliedly repealed 2002. His second form of argument was that the catch-up principle has come into being on account of the clause 4, and as a result of which our benefit which we get on merit that was deprived to us by clause 4. And the third round of argument was that the government of Assam has given two categorical affidavits stating that with the coming of the 2016 OM, the consequential seniority becomes void in terms of a judgment. Which your lord, in terms of certain judgments of the Supreme Court.
Which judgment?
Which judgment they didn't specify. That was the reason your lordship had called for the record. In fact, your lordship has asked a very pertinent question.
Why some judgment was
Yes,
required.
because that's a very pertinent question. Your lordship has rightly asked the question that what is the judgment by which it has been rendered null and void? Because the 78 Act and the 2012 Acts exist in Assam. It is not repealed. And the word was judicial
I
pronouncement.
think page 138,
Yes.
I believe.
Yes, one.
Has been rendered null and void by subsequent judicial pronouncement as
yes.
well as by
By
Act of 2012.
Malad, this is too wide a omnibus statement, and your lordship has rightly touched the right chord in asking for the record. Because whenever such a decision is taken at the highest level, definitely there has to be some reason. And in fact, this is the reason your lordship has called for the record. So this was the third point of argument. Well, my submission is that your lordship, I'll take your lordship very briefly to my affidavit in opposition, where I categorically answer all the questions.
Page number.
Yes, your lordship will take up my affidavit in opposition
You have to tell us,
in writ appeal 46.
tell us the running page number.
Yes, the running
sorry.
page number is 148.
148.
Yes, lordship.
This is reply, this is,
This is an affidavit in opposition by
okay, sorry, 148. This one additional affidavit by Narayan Hazarika.
no, lordship. This is an additional affidavit
That
by
starts at page 147.
this is an additional affidavit filed by Bhagwan Patar.
Can you locate the running page number?
Malad.
Can you locate the
Yes,
running
lordship.
page number?
This is filed by Mr. Pranab Turu to the writ appeal by respondent 10.
মানে index 2 পুরা করা নাই। Let's say.
Lordship 359. I was
359.
wrong. I was wrong. 359.
Barnabas Milton Queer.
Yes, Lord.
This one.
Malad, this is an affidavit which no one has placed. In fact, the government should have placed this affidavit. In the year 2011, before the division bench, the chief secretary government of Assam.
No,
gives
who
an
is
affidavit,
this person affidavit?
filed by the chiefs on behalf of chief secretary Barnabas Milton Quay.
Joint
He's
secretary.
the joint secretary government of Assam,
So this
WBT.
is a certificate by the joint secretary.
Yes, Malad,
And the others that pays 138? There by who?
349 is the
No,
this is the OM of 12 June 1996, bringing catch-up principle in Assam.
sorry, no. Just,
359, Lordship.
no, I'm coming to that.
Yes.
No, who filed the earlier affidavits that we referred just now?
Malad, the
That-
earlier affidavit which my learned friend had, that was filed by two persons, one joint secretary.
One is
Mrs. Sushma
Saedain Abbasi,
Abbasi.
additional chief secretary.
Yes,
That pays 134.
yes, yes.
Next one must be by
By joint secretary.
Narayan Hazarika
Yes,
and one.
by Sushma Hazari.
So we basically refer to Saedain Abbasi affidavit.
Yes, Lord.
So now this one is
This
filed
is
by,
by a chief secretary,
no, this one at page 357.
57.
This is by,
This is on behalf of the chief secretary.
one is by additional chief secretary, other is on behalf of the chief secretary.
Chief secretary. Malad, this will have more credence because it is before the division bench regarding a reservation matter.
Understand. Affidavits have the equal value.
Only the chief secretary is
The judgments of a division bench may have more value, but affidavits filed,
Malad,
things will be of the same
there is
value.
a reason to it. Because there they make a categorical statement in paragraph 2, if I may read, Lordship.
Paragraph 2.
Yes, Lordship. Can I read?
Yes, please.
That the deponent begs to state that the Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Service and Post Act 78 was amended in 2012 to implement the orders passed by the Honorable Supreme Court of India and R.K. Sabharwal. The Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Services and Post Act was published in the official gazette on 21st August 12, and it came into effect on 27/5/13 by gazette notification of the appointed date in pursuant to section 1(3) of the Amendment Act. And the rest
And
is
it
regarding
came into effect
quantifiable data.
by so and so
Yes.
amendment act.
So my submission, Lordship, is that
Department carrying on collection. So this only provides that section 5A was brought in to implement the order in R.K. Sabharwal.
Yes, and so my submission is that if the chief secretary has already sworn an affidavit stating that R.K. Sabharwal will be followed regarding post-based reservation where the merit part, the reserve get it on merit when they compete and not as a member of the reserve, but as a member of the unreserved, then how could clause 4 be brought in to deprive us of the benefit of that? That was my submission.
Sorry, please repeat
Yes.
the question.
Well, if R.K. Sabharwal, clause 4 of R.K. Sabharwal specifically says.
Clause 4 of R.K. Sabharwal,
Paragraph 4 of
Of,
R.K. Sabharwal.
of that OM,
No, judgment.
judgment, R.K. Sabharwal.
Yes, R.K.
Yes, eh? Paragraph 4 you are referring.
Yes, Lordship. Paragraph 4. R.K. Sabharwal.
When a percentage of.
When a
reservation
percentage
is-
of reservation is fixed in respect of a particular cadre and the roster indicates the reserve point, it has to be taken that the posts shown at the reserve points are to be filled up from amongst the members of the reserve class categories, and the candidates belonging to the general categories are not entitled to be considered for the reserve post. On the other hand, the reserve category candidates can compete for non-reserve post, and in the event of their appointment to the said post, their numbers cannot be added and taken into.
Yes, very well. A reserved person
Yes,
is competing against non-reserved posts
Yes.
on merit.
Mary.
that man will not be added to the reserve, and he will be as if he is a general candidate.
Yes.
This is what it provides.
Yes, so there is no bar.
Huh.
If there is no bar,
Can be done. Huh?
what necessitated, and when there are the 2014 OM of the government of Assam specifically also provides that on merit they get it, and not only they get it, at the higher cadre also they get it. I'll come to your lordship.
Sorry.
What necessitated the Assam government
Uh-huh.
to bring in clause 4 and deprive us of the benefit?
Deprive of what
Of the benefit of merit, because the clause 4 specifically
No,
says.
benefit you are entitled. Only what clause 4 provides is that the consequential seniority that you got
Yes.
by availing the route of reserved category accelerated promotion.
Yes.
If the quota for reserved had already been filled up for the further promotion,
Yes.
you are free to compete on merit as a general candidate, perhaps in conformity with para 4 of Sabarwal.
No, my lord. We are
But
not-
in doing so, you will not get the benefit of the consequential seniority. All
Malad-
that is all what clause
Yes, no,
4
it's a
provides.
factor, because lordship will find that if I read the clause 4, it says that you will get it provided earlier you never got it by accelerated promotion. And
No.
Yes, lordship. If I may.
No. I think Mr. Mojumdar had clarified it.
If I
Mojumdar,
can-
already been
Yes,
clarified by
I'll-
Mr. Mojumdar. That understand, he is not well signed. Mojumdar had clarified it,
Yes,
saying that if earlier you had availed accelerated promotion
Yes.
and also avail the benefit of consequential
Yes.
seniority,
Yes.
you can still compete on the merit stream, but in doing so, your consequential seniority benefit will not be only available.
No, my-
This is what he
Yes,
submitted.
yes.
I have noted.
I beg to differ, because if your lordship takes clause 4,
Hmm.
if you, can I read it? 133 of the April.
Clause 4 is
It is a 133 of the appeal law. Appeal number 46.
I'm taking it up from page 52.
Yes. Page 52, lordship. No, 52 is not legible. If on occasion arises, can I read? During the promotion process in which the stipulated percentage in respect of reserve is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion,
Hmm.
his or her case shall be considered for promotion on merit.
Hmm.
If such candidates has not gained that seniority by way of any accelerated promotion
So you-
earlier. What word is earlier?
So what is not gain seniority? This seniority means the consequential seniority.
Earlier. Yes.
Huh. By way of accelerated promotion. Even if you have got accelerated promotion, no difficulty.
Yes.
But provided you have not gained consequential seniority,
Yes.
meaning thereby, if you had gained consequential seniority, interpretation given by Mr. Mojumdar that you will still be entitled, but your consequential seniority gain will be taken off. Meaning thereby, suppose for coming in the zone of consideration, say there are 4 persons will come. By help of consequential seniority, you come within 4. Without consequential seniority, you don't come within 4, you'll be out. But even without consequential seniority, if you come within the zone of consideration number 4, you'll be in, you'll be considered.
But what they did, the fact that since they have brought down our seniority, taking this clause in all selection.
No, that will tackle separately.
Yes, yes.
We will give a meaning to this clause,
Yes,
and the meaning that will be given
yes.
has to be also given its effect.
Yes. So
If the giving of the effect
Yes.
is something more than the meaning given,
yes,
it has to be restored back.
yes. Well, yes.
And if the meaning given
Yes,
requires taking away of the consequential benefits, then it will be taken away. But if the meaning given that the consequential seniority had not been taken away,
yes,
but only when you compete in the merit stream,
yes.
as there is no further quota available, in that event,
Yes.
you may have gained the consequential seniority, you may not have gained, that will not be taken away. But for competing in merit, your consequential seniority will not be counted.
So what my submission is that clause 4 is in direct contravention of the OM of 2014, which I'll take your lordship. The OM of 29 December 2014.
No, see, we cannot examine 2016 on the basis of it being in contravention with any earlier notification. If we consider it in contravention of 2014, means we have to examine in contravention of 2002. Meaning thereby, as if 2002 is in perpetuity, it can never be changed. It is no. Because the reservation in promotion is by virtue of the 77
and
77 and 85 by virtue of 77th amendment to the constitution, which is admittedly and interpreted to be an enabling provision. Enabling means if you want, you can give. If you don't want, you may not give. Similarly, consequential benefit seniority is also an enabling provision under the 85th amendment. If you want to give, you can give. If you don't want to give, you may not give. Then comes these judgments in Nagraj and EP Power and a few others, which further circumscribes the power to give this reservation in promotion and consequential seniority. Circumscribed to the extent, again debatable with General Singh and all,
Yes.
that quantifiable data.
No, my lord, what has happened in Nagraj, there was no new proposition laid down. It only upheld the.
No, we are not going into those intricacies.
My lord,
Basic-
77
no,
and 85 was
what I
upheld.
am is trying out, point out the broad outlines.
Yes, my lord.
Broad outline is to exercise the enabling power, it must be backed by quantifiable data. Subject to again being increased and reduced in various judgments from time to time.
Yes, my lord, the Nagraj basically upheld the 77 and 85th amendment, and Jarnail Singh 1 and 2 also upheld it. So the learned single
Which judgment provided quantifiable data?
my lord, the quantifiable data which Nagraj provided.
No, where was the concept of quantifiable data?
No, the
First,
concept of Nagraj was
proposed.
regarding excessive reservation, which is not our case.
We are not on all those other aspects. By which judgment the concept of quantifiable data was introduced?
But in Nagraj, the concept of quantifiable data came in.
So this is where
because
we
that
are.
was regarding
We
excessive-
are, if Nagraj has 10 different points, we are not on the
Yes,
other
no, no,
line. We are on
no
only
issue.
one. Quantifiable data concept was
Yes.
introduced.
Yes.
Meaning thereby, if you want to give this benefit of reservation by promotion as well as consequential seniority, it must be backed by quantifiable data.
No, and
Definitely.
no, that is not the
No?
case. The judgment's main theme was quantifiable data was required if there was excessive reservation because reverse discrimination happens for the general. But in our case, it is never reverse discrimination because the 100-point register as fixed by the 2012 amendment.
This is not the issue here. Yes, Anime.
Yeah. So the learned single just said.
We are not going on any academics. We are only deciding the matter that is required to be
Yes.
decided. Yes.
Actually, what has happened, the learned single just made an towards the end, which my learned friend Mr. Ken Chaudhary had pointed out, that the reservation with promotion and consequential seniority may be given or may not be given, provided it is Nagraj and journal compliant. That was not, in fact, yesterday that was not.
May
pointed
be
out.
given and may not
Not
be
be
given.
given.
Where is that line?
Yes, my lord, we find that. Your lordship will come to the last part of the judgment. The operative part. Yes, at page 191 of the writ appeal.
191.
Yes, Lord.
Yes.
Article 16, 4A and 4B being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential.
This we read it at liberty to
At
provide
liberty
or
to
without
provide
consent or not,
without.
not to provide
not to
anything.
provide. However, there is a caveat, Lordship. Comma, while implementing, adopting, changing such policy, due process of law need to be followed, including dicta of Nagraj and journal. That was my case.
Mr. Das, let us take an example. There is a statutory provision enables X to pay rupees 10,000 to Mr. M.K. Chaudhary. Enables. It's not a requirement that you'll have to pay, enables. Now there is a subsequent proposition that if you want to give 10,000 rupees to Mr. Chaudhary, you must also show that you have 10,000 rupees in your bank. Only then it will be done. Now, in exercise of that power, X does not want to give 10,000 rupees to Mr. M.K. Chaudhary. Now, is the requirement of having 10,000 in the bank account required? For giving, it is required.
For giving you.
Only when you show, then only you are able to give, if you want to give. If you don't want to give, that is not relevant. Now, enabling power means you may either give or you may not give. To give, you have to satisfy certain requirements like this quantifiable data, etc. Or we are not going into any details of it, but broader outline, you have to satisfy something. To not give, you are not required. These enabling provisions does not mandate on the authorities that to give a consideration whether to give or not. And depending on the data available, you will take a decision either to give or not to give. It is not that provision. It is required only when you want to give. If you don't want to give, you can very well not give. It is absolutely your decision. This is what we understand.
Yes.
Now, enabling provision as a corollary to it, understanding is, suppose it is once given.
Yes.
You can at any time withdraw it also. It is up to you. Anytime you feel like, you can say that from now onwards, I'm not giving it anymore. To take a decision not to give it anymore is not dependent on the existence of any circumstance. It is dependent is your decision not to give anymore. So now, subject to what clause 4 of the 2016 OM provides for, to what extent it had been taken away,
Yes.
we will definitely read it
Yes.
as it is.
Yes.
But to take it away, there is no obligation or requirement that it should not be in conflict with 14, it should not be in conflict with something. That decision can be taken independently at any point of time.
Yes. But if.
So now, after reading clause 4 of 16, we'll find out what exactly had been taken away, or nothing had been taken away,
Yes.
or everything had been taken
Yes.
away. But this decision will be absolutely on the reading of clause 4,
Yes.
and it cannot be correlated with any other provision of 2014,
Yes.
etc. Because that will be a little difficult to
Well,
accept.
Well,
Uh,
2014.
Vis-a-vis the concept of exercising the power under a this enabling the provision.
Well, if the government of Assam is already able, it's an enable, it's an enforceable right. That was my argument.
As long as
It is enabled.
they are providing it,
Yes.
it's enforceable
And
right.
so my
Not
argument
only enforceable right, it has to be given to you.
given to it, there is a Supreme Court
But,
judgment also.
but they can also withdraw it at any point of time.
Malat, the question is that since the Assam government till now has
Not withdrawn.
not withdrawn the 2022, it's an enabling right. which-
Understand? We accept that.
Yes, yes.
That we are very much
And
with you.
in fact, Lordship.
Mr. Das,
Yes.
to this proposition, we are very much with you. So we will examine 2016
Yes.
only to the extent whether it had taken away everything, whether it had taken away nothing,
Yes,
or it had taken away part of it,
yes,
or it had taken away in a particular manner.
yes.
We'll examine only to that extent.
In fact, I'm confining my argument to what has been.
So now
stated
what
in
is
the-
your challenge to clause 4?
Yeah, the clause 4 challenge is that Lordship, at page 81, if your Lordship, I can take out to special.
Page 81, yes, straight to
Page
page just now.
81, which is the OM of 14. Schedule candidate, tribe candidates appointed on merit.
It is random decision. Yes.
Well, SC/ST candidates appointed on merit, clause 2.1, 3.1. If I may read, Lordship.
Before that, what is this document? Page 81?
This is the OM of 2014 where
Okay, 14
some guidelines are there.
Okay, very
That's the
good.
reason I brought it.
Which contains your 1.11?
Yes.
Same one.
3.1, Lordship, I'll read. In case of direct recruitment.
Then let us take one at page 45, because why it happens, I've already marked in
yes.
that one.
My, actually, that page is.
I
not
think that
legible,
is
so
part
I
of
will-
your pleading and this is the part of
Yes.
the other pleading.
In fact, it's not legible. Lordship will
page
go to page
47.
47. 3.1. In case of direct recruitment and promotion, SC, STP and SDH who has been appointed on their merit and owing not to reservation should not be shown against reserve quota. They are to be adjusted against unreserved quota.
What is your submission? 2016 is in conflict at 2013?
2016 clause 4 is in direct contravention of paragraph 3.1 to 3.3. Because the guidelines were already there, what necessitated the Assam government to bring in a clause 4 that has not been explained in any affidavit till today. Then I'll go to 3.2. If any unreserved candidate, the vacancy arises in a cadre and there is SC, STP and STH candidate within the zone of consideration in the feeder grade, feeder cadre, such candidate cannot be denied promotion on the plea, the post is not reserved. Such candidate shall be considered for promotion along with other candidate, treating him as if he belongs to the general category. In case he is selected, he shall be appointed to the post and shall be adjusted against the unreserved post. This is 3.2. And the last is 3.3. Similarly, ST, STH and STP candidates appointed on their own
You
merit.
can make out to what you're trying to submit from
Yes.
3.2, I think.
Yes, yes,
What
yes, ma'am. Well,
what you are trying to say, the concept that you are trying to propagate
Yes.
is flows from 3.2.
Yes,
3.2, it cannot be denied on the plea that there is not reserved
yes.
and can be considered along with other candidates, treating him as if he belongs to general category.
Yes. But by clause 3.3 is one step more. Similarly, ST, STH and P candidates appointed on their own merit by direct or promotion and adjusted against unreserved shall continue to retain their status of SC, ST and ST and shall be eligible to get the benefit of reservation in the next or future.
Suppose from executive engineer to superintendent,
Yes,
one reserved person
Yes.
gets promoted in the merit stream.
yes,
He goes to SC now.
yes.
From SC to additional chief engineer, he can again revert back to the reserve stream if he is otherwise
Yes.
eligible or
Yes.
this is the meaning.
But you are putting fettered by bringing in clause 4 by saying that you will be considered on merit provided you never got your earlier promotion by accelerated promotion in senior.
And
Earlier, they use the word earlier. Lord.
your apprehension will be clarified, don't worry.
Yes, my lord. Because what happened?
Your apprehension will be
Yes.
clarified.
Because they put a fetter on us and my argument was that since 2002 is in existence, since the 78 Act is in existence, since section 5 is in existence and section 5A is in existence, how could you fetter me with this right of getting the benefit of accelerated promotion and seniority? Because in the Jarnail Singh case, an argument was advanced by the general before the Supreme Court, 7 judges, that as they go up, there need not be, they lose their purpose of getting benefits, so they should be denied. Supreme Court says we will not accept this argument because if we accept this argument, we have to abrogate 16(4)A, which we will not do. This is a statement from, this is one of the paragraphs in Jarnail Singh.
In general. Sir.
Yes. So my submission is that the fact that I got promotion and seniority all levels, my seniority was never questioned. But in 16, you bring a clause, you debar me on merit on the ground that my earlier promotion was on accelerated promotion and seniority. I am completely out. So the fact that 2002 is still there means the government has enabled itself. Clause 16(4) is an enabling provision. It's an enforceable right. And I go to the court to vindicate it. The learned single judge rightly held that that part you cannot deprive of the benefit of merit because it flows from 78 Act. That is my submission.
Goes from the 70?
78 Act, section 5.
Okay.
And 5A. 5A is the post base. The second argument which your lordship, yesterday an argument was placed that an affidavit was filed by the government of Assam in Bhagwan Patar. It was not so, it was never filed in Bhagwan Patar. Bhagwan Patar case, 2 affidavits were filed, which the government have not placed it. I'm going to place it now. And
Which-
2 contradictory affidavits.
Which one?
Yes. Your
Sorry, I
lordship will
didn't pay
take up
attention.
my affidavit in reply.
Your last sentence, I did not pay attention. I was writing. What is the last sentence?
My submission is that yesterday an argument was advanced.
Yes.
My submission was, lordship, 2 very vital affidavits filed by the Assam government by 2 departments concerning Bhagwan Patar's case, filed before the single judge, was not placed on record. So it's my duty as a counsel.
Page number?
Yes, page number 319.
3?
319 of my affidavit in reply.
319.
My affidavit in reply, opposition.
Who is he? Personnel,
He is Mr. Debojyoti Sharma. He is the
personnel B
personnel
department.
department because Lordship, under the Act, personnel department and WPT work in tandem. He files his affidavit on 2/12/2016 in the Bhagwan Patter's case 5005. Your Lordship, I'll take your Lordship to the relevant para, page 324. Paragraph 15.
Oh. Okay. মোর T12 থেকে পাইছিল দেখো তো নাই সরি মোর ঠিকই আছে এটা গন্ডগোল হয়েছে কারণ মোর করেসপন্ডিং টু অনেক দুটা নাম্বার আছে সব এইটু আর কি 324 ডিগ্রিজ অলসো নহয় হেতুটো নিমিলে হেতু নিমিলে নিমিলিব It is by Debojyoti Sharma.
Yes.
Murkon thike ase. In the other copy, 319 is something else. That's why some confusion is there. In my copy, it is okay.
Yes.
I got it. নহয় গাঁঠোতে ইয়াৰে পিছৰ এফিডেভিটখন তাতে আগে দিছে তাৰে আগৰখন ইয়াৰে আগৰখন তাতে পিছত দিছে that's why the order in which the affidavits are in this brief it is not in the same order there so one affidavit which is a later in this one had been put before there and the one which is before had been put later in that one. I think that's why this is happening. Etu saifale aji correct kori thodi bolibo please. Yes sir.
Your Lordship will take your Lordship to page 324, paragraph 15.
24. Apnar tetya hole
Paragraph 15.
ei 324 pass to 329 khon also. Paragraph 14.
Yes,
324.
329.
Paragraph 14.
First line if I read.
30.
That with regards to statement made in paragraph 29 and 30 of the writ petition, the deponent states that in the absence of any provision for consequential seniority in the rules.
Where are you reading?
Paragraph
14 or 15?
15.
15, sorry. That
with regards to the statement made in paragraph 29 and 30 of the writ petition, the deponent states that in the absence of any provision for consequential seniority in the rules, the catch-up principle will be applicable and the roster point promotee reserved category promotees cannot count as seniority in the promoted cadre from the date of their promotion, and the senior general candidate, if later reach the promotion, general candidates will regain their seniority. The Honorable Apex Court has also held that 16(4) of the Constitution does not provide for consequential seniority automatically in addition to accelerated promotion to the roster point promotee. Malan, my submission is that it is the own affidavit of the Assam government personnel department that in the absence of rules, the catch-up principle revives. My case is that there is presence of rule. The rules are in the form of the OMO 2000. So it is absolutely a wrong information given by the government.
That's right. Ultimately, the entire aspect to be considered is whether 14 in any manner, 16 in any manner had abrogated 2002. If it has not, 2002 survived. If the meaning given is it has done, 2002 is no more, so catch up principle. And these are the general propositions. The core fact we are required to determine is understand 1.1 of 14,
Yes.
what it provides for, read with that 14 or something of that same, that last paragraph,
Yes, Lordship.
one of the second last paragraph,
Yes. Yes,
That-
clause 14.
that
It is.
some
it
repeals
amends-
all other something to the extent provided or
yes,
something.
It amends everything.
Events to the extent
Except
provided
Provided,
and 2016.
yes. Clause
If
4.
these two provisions does not abrogate 2002, 2002 consequential seniority remains.
Remain.
If it abrogates, it goes. If it abrogates in a particular circumscribed limited manner, it is to that extent. Remaining balance will remain.
Yes.
This is only,
Yes, my lord, in fact, why I'd say, my learned friend argued that he took the benefit of Penasilvam judgment. I want to distinguish. In Penasilvam judgment, there was no rule like Assam. So the Supreme Court says in the absence of rule, the catch-up principle comes.
just, that's Silvam.
Yes, Penasilvam. So my argument
No,
is that,
Penna Silvam, his argument
My lord.
was, yes,
that catch-up principle comes,
Paneer Silvan.
Penasilvam,
Paneer. I don't know, I written Paneer. Paneer Silvan, Mr. Chaudhary relied on para 36.
Yes.
That's all.
Yes, and in
What does
fact,
para 36 provide? He does not rely on anything beyond
no,
that,
he-
other
he-
than
he
36.
only says that the catch-up principle revives.
That's all.
Yes, but in Tamil Nadu's case, there were no rules as such as in Assam, the 2002 rule is there. So in Assam, since there is no absence of rules, the
Very
catch-up
well,
principle can
that
never
we have
revive.
already accepted. You
Yes,
did
yes.
not,
Because that is a vital argument he
that
had.
you need not reiterate it again. and
Yes.
again. 2002 distinctly provides for consequential seniority.
Senior. And
So now
state
the
has enabled-
only issue before us is
Yes,
whether any clause of 14
Yes.
and any clause of 16
Yes.
in any manner had abrogated. it.
abrogated, that's the issue.
If we decide yes, it is yes. If we decide no, it is no. Or if it is anything in between, it is that in between to that extent.
Yes.
That's all.
And
So these Paneer Silvan catch up automatically revive. These are the general propositions.
Malad, since
So-
you wanted to argue on that point, I have a counter.
Mr. Da, just because it is argued, it need not
You
be
as
that,
lawyers have to argue
that,
because it might go
that
against
itself
us.
is that. Because difficulty is the lawyer will argue to,
Yes, to perfect.
to an unlimited extent.
Yes.
There is no limit,
Definitely.
but,
I agree with you.
but we cannot go to an unlimited
No,
extent.
no.
We have to confine ourselves
To.
to the list involved in a
least
given matter.
Because the power of finality is only with your logic.
Non-finality, we confine ourselves to the actual list involved.
Yes, listen.
We cannot go beyond the list involved.
The fact that this argument was one of his anchor sheet argument, I am countering it to say that Penasilvam is not applicable. Secondly, Lordship, I'll take to the second affidavit, another very important affidavit by the WPT department, which is the
Page number?
nodal agency, page 327.
327. It's a different affidavit or same one
No,
continuing?
same, in Bhagwan
Different.
Pathar.
Uh-huh.
He is Mr. P.K. Hajauri. He is the commissioner to the secretary to the WPTBC department, because this is the nodal agency.
327 affidavit.
Yes.
Yes.
So in his affidavit in Bhagwan Pathar,
এখন ক'ত পালে আপুনি? কোন পেজত? 327 আকৌ চাব লাগিব। 327 by P.K. Hajauri. আপুনি সেই আগৰ পৰা 2019 বিগিনিংখন চাওক, সেইখন হাজৰি হ'ব পাৰে। এইখন 33 হ'ব দিয়া বোলো। Yes, P.K. Hajauri.
yes, Malad,
Which
his
paragraph?
affidavit clearly shows
Para?
that the, Malad, before I go to paragraph 6, I'll
Hmm.
just make a small submission to connect it with the paragraph.
Yes.
He being the nodal agency, they take a categorical stand before the Bhagwan Pata's case, in the Bhagwan Pata's case, that the OM of 2006 clause 4 is defective. Because the House Committee has gone through
See,
it and OM of 2016 clause 4
is
is defective. Is not in consonance with Supreme Court's order, so it needs modification. This is his categorical state.
so let him do, but we cannot ignore it.
No, yes. So I just want to.
So
read
if
that.
if one official feels that it is defective, requires reconsideration, it is for the government to do it.
Yes, Malad, he has already placed it. That
Yeah.
is the thing I wanted.
He may have placed, but as long as the decision is not forthcoming,
Yes.
we can't take
Yes.
note of
So since the affidavit was given, I thought it proper.
which paragraph anyway?
Paragraph 6, Lordship.
Paragraph 6.
If I may. read
Mr.
that.
Das,
Yes.
I was also on the other side
Yes.
at one point of time. There, the entire concept is to diverge as far as possible, so that your argument will engulf everything that you want to say. Now our idea is to converge, so that ultimately we can write down something. Because if we start going on diverging, we'll never reach any end anywhere. Days after days, we'll go on hearing. So, and one of the aspects to be taken note of is, what is the actual list involved in the matter? Converse to that.
So this is basically my submission.
Now, that agreed by the OM, the petitioner himself filed the governed in a department on being served with a notice. So had several rounds of deliberation and held several meetings on being the government, the WPT, on being held with the assembly considered W passed unanimous resolution and meeting dated that the OM requires some modification. Draft OM prepared, containing clause based on suggested modification. Draft is being sent to the person for vetting. After vetting, there will be same for the. So what happened ultimately? This was an affidavit of 2017.
Yes.
Now in 2023, what happened?
Well, nothing happened because they continued with it and.
So this is a redundant piece of.
Well, only one thing I want to show that at different points of time, the Assam government gave affidavits at different forums in different writ petitions, and resulting in what, Manoj, that towards the end, oblivious of the fact that the chief secretary in 11 had already made a categorical statement, we will stand by R.K. Savarkar. That is.
R.K. Savarkar is a point-based.
Post-based and
post-based reservation.
So my final conclusion is that 2014 is a specific area which talks about post-based reservation. The
2014 is for the purpose of introducing the
post-based
reservation,
implementing
the implication thereof, and if introducing post-based affects seniority in any manner, clause 1.1 clarifies that that seniority will not be material.
Because the rules
Suppose because of the introducing the post-based, some seniority which otherwise would have been on vacancy based is affected in a different manner. That effect will not be taken note of. That is provided in 1.11.
1.1. And the rules.
So this is 2014.
Yes. And
2016 is a result of the judgment of the court in that the Equality Forum, where court observes that some kind of a reconsideration is required. And 16 is out of that exercise.
And
where there is a clause 4. 4 provides something which is clearly worded. And we understand what is those clearly worded. Okay.
And 2002 is the implementation of the 85th Amendment.
That is, in our mind, we are clear.
Yes, that is fine. These were the areas.
And 2023, we'll hear you later on.
Yes.
When you hear that
Separate
repetition.
challenge.
Let us not mix up here.
Yes,
Yes, Mr. At least you can have a beginning because you'll have to rise around 4:15. Lordship is having a
Yes, ma'am.
bench by
I'll
virtual
just
mode
give
with
you
or
my-
in
what will be
Arunachal.
My submission.
Sorry.
I'll just give a brief idea of what is what.
So
will be-
now, no, now we hear you totally separately because yours is an independent writ petition. Which could have been decided independently without being engulfed in a common judgment with the other one.
Yes,
So let us hear you.
yes.
And if you can make out a case for an interference, we'll definitely put it across the other side. And this judgment, we all intend to write in such a way that this common judgment is in respect of two writ petition, 5005 and 5026. 5005 is in this respect. 5026 is in this respect. So we are dividing our judgment also into two equal parts.
Right.
May not be equal also into two parts. First part, we consider the aspects of 5005 and decide what had been transferred till now in the required manner. 5026 will hear you and decide it
Right.
in its own
My lord,
manner.
that will be very fair.
Please start.
My lord, the
Although you have only 5 minutes today, please start.
Yes, my
That is, let us have
my
a beginning.
submission will be, my lord, one and only one. That is, my lord, the state could not have issued the memorandum without following the requirement that has been laid down by the Supreme Court of two requirements: collecting quantifiable data, and based on the quantifiable data, the state has to form an opinion. Only then the enabling provision under Article 16(4)(a)
It can be exercised.
And for that, my lord, I'll rely on the judgment of Nagraj and my lord Jarnail Singh, and also the earlier judgment of this.
Of the
Honorable Court.
Equality Forum.
Equality
Equality Forum had discussed all these aspects
Yes,
to
ma'am.
a great extent,
Yes,
what I have read.
Therefore, my lord, my submission will not take much time.
So your submission is before this OM of 2016 was issued, there was also a corresponding requirement to examine the quantifiable data if available, and only thereupon to issue
No,
2016.
thereafter, my lord, the state has to form an opinion.
Okay, fine.
Yeah.
A form opinion and then issue 2016. Otherwise not.
Otherwise. And for that, my lord, I'll rely on certain paragraph of Nagraj, and which has also been, my lord, reiterated.
Why is your submission that this
My lord, after the,
existence of that quantifiable data and opinion is necessary for
my lord, that is the
2016?
judicially evolved principle, my lord. After these Article 16(4)(a) and 4(b) came into being.
No, I'm not asking the question from that point of view. Had you challenged 2002, I understand. That 2002 quantifiable data was introduced without satisfying these requirements. Although some of the requirements may have been put in place by judgments subsequent to 2002. But why 2016?
My lord, so far as 2002 notification is
That
concerned.
I understand. If you want to challenge 2002, you are absolutely right and spot on, saying that without undertaking this exercise and forming the opinion, you cannot put in place consequential seniority. That is,
In fact, my lord,
in fact,
2002
it's a statement from
2002
our side. We 100% agree with you. But why the same principle to attack 2016?
My lord, so far as 2002, my lord, the notification is concerned, that was put to challenge in another petition earlier. I think my
Yes.
friend.
In the
may have-
Bhogeshwar Saikia's case,
That is already
that
decided.
is decided in our favor, that.
Whatever it is.
No, that I am saying, my lord, that in Bhogeshwar Saikia's case, I was the counsel, my learned friend was assisting me, my lord, in that case. There, my lord, the question was whether the state can issue such a notification without amending the provisions of the Act,
Act is at 1978.
1978 Act. And the
No.
honorable court, my lord, has
No, no.
held
1978 Act, if I have read it correctly, Section 5 provides for reservation in promotion.
yes,
It does not provide anything as regards consequential seniority.
my lord,
2002 provides for consequential seniority.
my lord.
So there is no relation or any interdependence of the OM of 2002 providing for consequential seniority
With section 5.
and Section
Yes,
5.
yes.
So if that is a judgment, it's
That-
rendered by single bench or division bench.
It was by single bench.
We can ignore it.
Yes,
It has no meaning in law. It clearly does not have a meaning because for consequential seniority, when there is nothing provided in that 1978 Act,
Right.
why you should fall back on that to determine something?
Yes, my lord, that judgment has to be ignored. That is, that
I
is.
think it has to be, Bhogeshwar has to be ignored in that case. And I think here at least we can do it.
Yes, ma'am.
Mhm.
Because my lord, nothing was decided regarding validity.
To
of
that
the-
extent, we can clarify Bhogeshwar also.
Yes, my.
And then beyond that, further,
My lord, the 2014, my lord, notification was challenged in the earlier litigation by Equality Forum.
even earlier,
Yes, my lord. And my lord.
there sorry, I'm interrupting again and again. Means I'm putting it to just put it across straight
Yes.
that we have it what you're required to have. 2014 basically delves into the requirement of quantifiable data
Yes, ma'am.
in one sentence.
Yes, ma'am.
Court arrived at a conclusion that it is a requirement.
Quantifiable data is a.
Is a requirement. Anything done without it requires some reconsideration. So court says, let the government reconsider the whole thing.
Yes.
I think that is the Equality Forum and nothing beyond that.
Yes, my lord.
Nothing has been set
aside.
aside, nothing has been declared null and void. Only thing,
The report, my lord,
again
no,
in the
there-
nature
there
of
was
a-
a, my lord, 1-1 commission report. That
Huh.
report was, my lord, set aside. There was a quantifiable data, my lord, collected by the state. And my lord, this honorable court found that the data.
That is inadequate.
Is of not.
That Sonwal, Harish Sonwal.
Insurance Commission.
So now,
Now, what I want to, my lord, project is that this office memorandum of 2016 was issued, putting some paragraph of the earlier Equality Forum judgment selectively and ignoring certain, my lord, paragraphs which are relevant.
Mr.
and that
Chaudhary, frankly speaking, 16 is a mess.
2016.
2016 is a mess.
Mess, it has to go, my lord. It has to go.
That's what I say. 16, I gave you an example. From Chanmari, you start towards Panbajar. Instead of reaching Panbajar, somewhere on Guwahati Club, you take a left and go to
Yes,
GS Road and reach Ganeshguri. It is something of that nature.
quite true.
Starts it in one direction, ends up somewhere else. So where it started, while starting whatever is quoted, if you give too much of importance to that, it will not lead anywhere because ultimately it goes somewhere
We have
else.
diverted already.
Had it gone in the right direction, it's okay.
But then, my lord, the basic question is, my lord, whether the mandate that has been laid down by the Honorable Supreme Court in Nagras and subsequent judgments have been followed while issuing the 2016 notification.
Only that much.
Only that much.
But considering what is provided in 2016, it's immaterial whether it was followed or not. Although there is a requirement under the law to follow it.
Yes.
But in 2016, whatever is provided,
No, 2016.
Nothing is provided
memorandum
there.
has provided the procedure that has to be adopted while giving reservation in court.
which clause?
But the entire notification is on that.
Okay, from tomorrow we'll read that 616 as a whole
Yes, my lord.
and find out
Yes.
which of the clauses are offending
Yes.
or whether the whole of it is offending, and I can only take a call.
Right.
Hmm. Otherwise, that's what I said. No, we have to converse and arrive at some conclusion here
That's
and
why, my
there.
lord, I'll confine my argument to the, my lord, the
2016?
principle that
Ah.
whether the principles that has been laid down by the Honorable Supreme Court, which are mandatory, that has been followed or not in while issuing the
Principles for what purpose? This is the difficulty.
principle for the purpose of
Principles for consequential seniority.
no principle
For reservation in promotion.
exercising the my lord, the enabling provision, the power under the
No,
enabling
enabling two provisions are there, one for reservation and one for consequential. Which one? Or both?
both, my lord.
Both. So your grievance is by 2016, the reservation in promotion had been maintained, as well as to some extent consequential seniority had also been maintained without following the.
In fact, my lord, we did not raise any grievance regarding the, my lord, consequential seniority. We are confined
Only reservation. You,
Yes.
according to you,
only on reservation. At least in the writ petition, my
so
lord,
the
there was-
relief that we can give you is, why set aside 2016? We can give a direction that these are the requirements of law.
Yes.
You kindly take the requirements and take a
Yes,
decision.
provided you intend to give reservation, then you have to follow these two.
So you take a decision,
Yes, my lord,
but
that-
that will may not call for a setting aside of 2016.
my lord,
2016 is for some other purpose.
So if this 2016 remains, my lord, then.
No. Suppose tomorrow the decision is pursuant to a direction that you take a complete decision, firstly on reservation in promotion and secondly on consequential seniority vis-a-vis both. Not vis-a-vis both, if it is on reservation and there is no reservation, there is no consequential seniority also.
Yes.
It's a consequence of that only. Then that decision will abrogate everything from 2002 to 2014 to 2014
Everything.
may not be, 14 is of something different. 2016 both.
This one.
That will be sufficient
That will
for,
be sufficient to decide the, my lord, the issues in both the writ petitions.
so we can proceed in that. They'll take a decision. We'll just think Equality Forum required a decision to be taken. Although 16 is stated to be pursuant to their award, it appears that it is inadequate and not the actual requirement. So pursuant to the earlier direction, you may take that decision.
Yes, fine.
16, for the time being, remain as it is. And in the other petition, we interpret 4.
Or whether, my lord, the 16 should remain or not, on that, my lord, I may make some comment. Otherwise, but that
No,
part is
no.
fine.
If we say 16 is not to remain, that means the decision the government is required to be taken, we ourselves is taking. We cannot do that.
My lord, if
Somebody is waiting in Itanagar for. No, otherwise, if we say 16 cannot remain, that means, which provides for something, that means the decision we ourselves have taken.
no, my lord, you will be.
Whereas it is a requirement of the government to take that decision.
No, my lord, your lordship may say that this is not in accordance with the guidelines, therefore you exercise your power. and-
That's what we say. We are open for that. The exercise of power and as well as the requirement of the earlier Equality Forum had not been duly complied with, you take the decision,
Yes.
whichever way you take.
Yes, my lord.
Obliged.